Submission of the website. Serial number 25 case. ನಿತಿನ್ ನಿನ್ನೆ ವೆಂಕಟೇಶ್ ಸರ್ನ ಕಳಿಸ್ತೀನಿ ಅಂದರೆ ವೆಂಕಟೇಶ್ ಸರ್ಗೆ ಕಳಿಸ್ತೀನಿ ಅಂದರೆ ಎಲ್ಲಿ ಹಾಂ ಹಾಕಿರ್ಬೇಕಾ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಆಕ್ಟ್ ವಕಾಲತಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೊಡಿ ಅಂತ ಹಾಂ ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ಆಕ್ಟ್ ಅಂತ ಆಗಿದೆ. ಅಫಿಷಿಯೋ ಆನ್ ರೆಕಾರ್ಡ್ ಇದ್ದಾರೆ, ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. ಸತೀಶು ರಾಘವೇಂದ್ರ ಇಬ್ರು ಇದ್ದಾರೆ. ಅವ್ರು ಬರೀ ರಾಘವೇಂದ್ರ ಹೆಸರು ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಏನಿಲ್ಲ, ಆಲ್ರೆಡಿ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆಗಿದೆ. ಪರ್ಮಿಷನ್ ಏನು ಬರಲ್ಲ ಈಗ, ಲೋಡ್ ಅಂತ ಮಾಡಿಸ್ಬಿಡತ್ತೆ ಅಷ್ಟೇ. ಸಂಜೆ ಹೇಳಿದ್ರಂತಲ್ಲ ಹಾಂ ಹೇಳಿ. ಹೌದು ಸರ್, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ, ಇದು ನೋಟಿಸ್ ಆಗೋಗಿದೆ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಕಂಪ್ಲೈ ಮಾಡ್ತೀನಿ ಟೈಮ್ ತಗೊಂಡು ಮಾಡೇ ಇಲ್ಲ. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿಸ್ಕೊಂಡು ಮಾಡೋದಾದ್ರೆ ನೋಡಿ, ಮೈನರ್ ಆಗಲೇ ನೋಡಿದೆ, ಒಂದೇ ಇರೋದು ಅಬ್ಜೆಕ್ಷನ್ ಅಷ್ಟೇ. ಹಾಂ, ಟೈಪೆಡ್ ಕಾಪಿ ಆಫ್ ಮ್ಯಾನುಸ್ಕ್ರಿಪ್ಟ್ಸ್ ಅಷ್ಟೇ, ಅದೊಂದೇ ಇರೋದು. ತಂದಿಲ್ಲ. ಇಟ್ಸ್ ಬಿಟ್ವೀನ್ ಯು ಅಂಡ್ ಸರ್. ಹಾಂ, ಯಾವ್ದು ಹೇಳಿ? ಹಾಂ, ಇಲ್ಲಿ ಬರೀ ಎನ್ ನಂಬರ್ 25 ಡೇಟ್ ತಗೋಬೇಕಿತ್ತು ಸರ್. ಬಂದ ತಕ್ಷಣ ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಕು. ಅಂದರೆ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ ಅಂತ ಇದೆ. ಆ ಥರ
My lord, in case the offences are included and complainant has been served with a notice.
File it. Serial number?
32.
So since 5 years he's in 5.5 years he is in custody. Counsel for the appellant prays for time. The appeal is of the year 2020. As per office note, the appellant accused is in custody since for about 5.5 years. I do not find any reason to adjourn the matter, however, to offer final opportunity. Yes. 10. So third time it is posted. Third time. Go ahead. Praise for time. Allah hakondu. Finally, as the last chance.
List 1, page 1, non-compliance of office objection.
3 weeks are moving on. Not being listed.
Final hearing. Final hearing.
ನೋಡಿ ಅದು ಏನಾಗಿದೆ ಅಂತ ಟ್ರೇಸ್ ಮಾಡಿ ಮಾಡಲಿಕ್ಕೆ ಏನು ಬೇಲ
ಇಲ್ಲ ಕನ್ವಿಕ್ಷನ್
ಲಿಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ
ಸ್ವಾಮಿ ಸೀರಿಯಲ್ ನಂಬರ್ 25 ಸ್ವಾಮಿ ಫ್ರೈಡೆ ಡೇಟ್ ಬೇಕು ಸ್ವಾಮಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ್ದೀವಿ
25
ಸೀರಿಯಲ್ ನಂಬರ್ 25 ಸ್ವಾಮಿ ಫ್ರೈಡೆನೆ 25 ಗೆ
ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಪ್ಲೀಸ್ ಫಾರ್ ಟೈಮ್ ಲಿಸ್ಟ್ ಆಫ್ 4 weeks
ಮಚ್
7 second time case time
my lord serial number 3 my lord kindly wait madam
3 praise for time 2 praise for time serial number 2 list number 2 praise for time finally as the last chance adella hakkoli in custody since more than 3 years
Serial number 13. List number
13 non compliance ಅದೇ ಆರ್ಡರ್ಸ್ ಗೆ ಬಂದಿದೆ ಆರ್ಡರ್ಸ್ ಗೆ ಯಾಕೆ ಬಂದಿದೆ non compliance counsel for the 13 counsel for the appellant prays for time office objections are not yet complied with this time. Next.
This one page 1 non-compliance of office objection for first time serial number 1 Prasanna Kumar B.
Appellant matter. Really objection number 6.
Number
6. ಅದು ಎಂಟೈರ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಇರೋ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹ್ಮ್.
ಅದು ಪೇಜ್ ನಂಬರ್ 25 ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಸರ್. ಕಂಟಿನ್ಯೂಸ್ ಆರ್ಡ್ರು, ಹಾಗಾಗಿ ಪೇಜ್ ನಂಬರ್ 15 ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಇಲ್ಲ ಅಂತ ಮೇ ಬಿ ಓವರ್ ರೂಲ್ಡ್. 15 and 25.
Third learned counsel for the appellant on office objection at serial number 6. The cause title of special case number 46 of 2022 is found at page number 25. Submission is accepted. Submission of the learned counsel for the appellant is accepted. Office objection in that regard is ignored. If all the office objections are, counsel for the appellant submits that has complied with all other office objections. Office to verify. HCGP to take notice for R2, R1. R1. Issue notice to respondent number 2. Yes. Issue notice.
Sirajuddin Ahmad.
37. Please time.
Serial number 2, Patil Jayashree.
Please time. Yes, complaint.
Serial number 3, Arjun, non-compliance for second time. Serial number 4, Anil Kumar CD.
Observe no representation. Yes, sir.
Serial number 5, Vikyat.
Which the objection, they say the second objection, which is there is a typographical error in the order of conviction and sentence. Written counsel submission.
State the offense to be stated correctly.
What?
Offense to be stated correctly in the prayer column.
Malach, it is 4.4 subclause 2. We've stated 4 subclause 2, but that was the objection which is raised. But in the order of sentence, it is 4 subclause 2 only. That is the main contention. So if my lords may kindly peruse on to page 69 of the judgment. At the bottom line, the accused number 4, so the appellant is accused number 4, is sentenced to undergo imprisonment for a period of 20 years for the offenses under section 4 subclause 2 of POCSO Act. So that is the only objection.
Counsel for the appellant on office objection at serial number 2 with regard to the prayer in the prayer column. Counsel for the appellant draws the attention of the court to running page number 69. That is the operative portion of the order of the trial court. To contend that he has mentioned the provision as mentioned in the operative portion of the impugned judgment. The submission is accepted. What about the one, serial number 1?
It's been complied with.
Counsel for the appellant submits that he has complied with office objection at serial number 1. Office to verify. Issue notice. CGP to take notice for respondent or to issue notice. Yes.
Serial number 6, NS Sampangi Ramaya.
The office objection is mirrored. Serial number 1, victim should not be made as party intide. Adike our tayin party madidini swami already. Complaint.
Prayer with regard to punishment to be stated correctly.
Adella madidini swami. Except your serial number 1 matra objection is.
Ade serial number adu. Prayer with regard to punishment to be stated correctly.
I will do it. 2 days time.
Counsel for the praise time.
2 days.
Serial number 7, Arjun, non-compliance for third time. Serial number 8, NS Sampangi Ramaya.
ಇದರಲ್ಲಿ ಅಷ್ಟೇ ಸ್ವಾಮಿ ಇದು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಬರ್ದಿಲ್ಲ ಮತ್ತೆ ಅಪಲೆಂಟ್ ನೇಮ್ ತಿಮ್ಮಯ್ಯ ಅಲಿಯಾಸ್ ತಿಮ್ಮ ಅಣ್ಣ ಅಂತಿದೆ ಅದನ್ನೇನೋ ಉಲ್ಟಾ ಬರ್ದಿದ್ದಾರೆ ಅಂತಿದೆ 2 days time I will do the need. 2 ದಿವಸ ಸಾಕು.
5 objections are there.
I will do it within 2 days.
Third time it is posted. Finally I will post.
Please madam.
Counsel for
Please.
the appellant pays for time to comply with the office objection. The appeal is listed for the third time to comply with the office objections. I do not find any reason to adjourn, however, to offer final opportunity. finally.
Serial number 9, Sharat JM.
And in this case, for the appellant, victim is not made a party and the office objection is there. Since the trial court is acquitted for the offense of the SCST Act, the trial court only convicted 326 and 324 of IPC. Hence, not made a victim as
Third
party.
learned counsel for the appellant on office objection.
The operative portion is 46.
As the original, or as the complainant is not made as party. Learned counsel for the appellant submits that the appellant was acquitted for the offense punishable under section under the provisions of SCST Prevention of Atrocities Act, and therefore in pleading of the complainant as a respondent is not necessary. Okay. Submission is accepted. Office objection in that regard is ignored. Issue note. HCGP takes notice for so and so. R2 issue notice. Yes, issue notice.
Obey.
Serial number 10, Arjun. 11, Somshekhar.
Police report. As per police report, respondent number 4 to 8 are served, called out urgent. Yes, R2. We may have to furnish fresh address. Respondent number 2 could not be served as he is now residing at Hyderabad and not residing in the given address. Counsel for the appellant place for time. This time. Please furnish the correct address.
Please, madam,
Furnish the correct address. Next.
furnish.
Correct address.
We are having only one address. In addition to that, we don't have any. It is the duty of the police to search where it is that.
Then you have to seek for issue of NBW.
Please.
ಸುಮ್ಮನೆ ನಿಂತ್ಕೊಂಡ್ರೆ ಅಷ್ಟು ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಸುಮ್ಮನೆ ನಿಂತಿದ್ದೀರಿ ವಿತೌಟ್ ಎನಿ ಎಕ್ಸ್ಪ್ರೆಷನ್.
No, NBW may be issued, madam. Please.
ಏನು
NBW may be issued.
ಅದು ಮಾಡ್ಬೇಕು ನೀವು, ನಾವೇ ಯಾಕೆ ಮಾಡೋಣ?
I am praying this honorable
ಏನೂ
court to
ಇಲ್ಲ,
issue.
ಸುಮ್ಮನೆ ನಿಂತು ಹೀಗೆ ನೋಡ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲ, ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅನ್ಕೊಳ್ಳಿ. ಆಯ್ತು. Kindly issue the NBW against the R2.
Could not be served and he is not found in the given address. Counsel for the appellant place for issuance of NBW, as he is not aware of the present address of the respondent number so and so. Issue NBW. Yes. Next. Pay PF for it.
Please,
Next.
I will pay.
Number
Much.
12, Somshekhar.
This appellant in this matter. A notice has been whether issued served or not.
Respondent number 2 to 4.
ಇದು ಬೇರೆ.
HCGP place for time. Yeah. Yes.
Much.
Serial number 13, Arjun. 14, Shivu D. Shivu.
ಅಯ್ಯೋ ಒಂದೇನು, ಅಯ್ಯೋ ಒಂದು so 1 and 3, 2 and 4 are similar. Crossover.
Hearing on IA, serial number 15, Government Advocate.
HCGP place for time. Next.
Serial number 16, P. Prasanna Kumar, M.
So for the
Satish.
appellant is urgent. HCGP place for time.
But I've arrayed my lords respondent number 2 as a party. They have now filed an IA my lord seeking permission. IA is not served on me, my lords.
No, IA 1 of 2025 permission for.
No, that is not filed by my. They have filed it. They have not served the copy. It appears, my lords, to seek permission to appear.
ಯಾರು ಮಾಡಿದ್ದಪ್ಪ? R2
They're already on record.
bail ಇದು. Counsel for the applicant under A1 of 2025 is absent, no representation. ಎಂಥದಿಲ್ಲ, ಸುಮ್ಮನೆ ಪ್ರೇಯರ್ ನೋಡಿ ಹೇಗಿದೆ ಅಂತ. The office objection raised on the application is not complied with. List. Yes.
That's date may be fixed.
Yes. Next.
The number 17, B. Srinivas B.S. Prasad.
Office objection have been complied, my lord, yesterday. Office objection have been complied, my lord, yesterday.
Counsel for the appellant submits that he has complied with the office objection. ನಿನ್ನೆದ
My lord, we have filed an application under 430 of BNSS, my lord. We'll file an SLP, my lord, in the Supreme Court.
Now what is your prayer? Suspension.
Lord, suspension of sentence till then. my lord.
Counsel for the appellant filed year 2 of 2025 seeking suspension of sentence. The appeal preferred by the appellant is allowed in part with a judgment dated so confirming the judgment of conviction and modifying the order of sentence. For the reasons stated in so and so, IA 2 of 2025 is allowed. The order of sentence imposed, order of sentence passed by this court today, dated so and so, is suspended for a period of 60 days, 30 days, 30 days. Yes,
So, yes.
Subject to conditions.
Serial number 18, B. Latif.
Kindly pass over. Senior is on objection.
Serial number 19, Chandrasekhar Parmeshwar.
ವಯಸ್ಸು ಯಾರು ಅಪಲೆಂಟ್ ಯಾರು?
Chandrasekhar.
ಅಪೀಲ್ ಮೆಮೊನೂ ಹಾಕಿಲ್ಲಲ್ಲ. ಅವ್ರು ಮಾಡಿಲ್ಲ ತಾನೆ? I will adjourn this. I will adjourn the matter. I will adjourn the matter. ಅವ್ರು ಇಲ್ಲಲ್ಲ, ಅಪಲೆಂಟ್ ಇಲ್ಲ. ಏನ್ರಿ ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ತಾನೆ, ಅಪಲೆಂಟ್ ಮಾಡ್ಬೇಕಲ್ವಾ? Counsel for the appellant is absent, no representation. List on. Next. ಏನು ವಾಟ್ ಈಸ್ ದ ಅರ್ಜೆನ್ಸಿ ಸರ್? ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಏನು ಅರ್ಜೆನ್ಸಿ? ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ, ಮತ್ತೇನು ಅರ್ಜೆನ್ಸಿ ನಿಮಗೆ? ವಾಟ್ ಈಸ್ ದ ಅರ್ಜೆನ್ಸಿ? ಹೇಳ್ಬೇಕು ಏನು ಅಂತ. ಯಾಕೆ ಅಂತ? 2023 ಮ್ಯಾಟರ್, 2010 ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ವಾಟ್ ಈಸ್ ದ ಅರ್ಜೆನ್ಸಿ? When appellant is not having any urgency, what is your urgency? ಏನಾರು ರೀಸನ್ ಬೇಕಲ್ವಾ ಅದಕ್ಕೆ? ಎಸ್, ನೆಕ್ಸ್ಟ್. ಶಾರ್ಟ್ ಏನ್ ಬೇಡ, ಅದು ಮುಂದೋಗ್ಲಿ.
Serial number 20,
Appeal for
Avinash
the
BB.
appellants. File the appellant.
ಅಲ್ಲಿ absent, counsel for the appellant is absent, amendment is not carried out, amended cost title is not furnished. List after 4 weeks.
Delay ಆಯ್ತು ನೋಡ, ಅಫಿಡವಿಟ್ ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
Counsel for filed.
ಫೈಲ್.
Counsel for the appellant filed the affidavit in support of IA 1 of 2025. Counsel for the appellant submits that it is the better affidavit, assigning reasons for the delay of 440 days in preparing the appeal. What is the reason?
ಸ್ವಾಮಿ ಅವರು ಅಕ್ಯೂಟ್ ನಂಬರ್ 213 ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ ಇದ್ರು ಸ್ವಾಮಿ, ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ 3 ಮೆಂಬರ್ಸ್ನು ಆ ಶ್ಯೂರಿಟಿ ಫರ್ನಿಶ್ ಮಾಡಕ್ ಆಗ್ತಿರಲಿಲ್ಲ, ಮತ್ತೆ ಅಡ್ವೊಕೇಟ್ ನ ಪ್ರೊವೈಡ್ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಶ್ಯೂರಿಟಿ ಯಾಕೆ ಬೇಕು ಸರ್?
ಅಲ್ಲ ಅಡ್ವೊಕೇಟ್ ಪ್ರೊವೈಡ್
ಮಾಡೋದಕ್ಕೆ ಶ್ಯೂರಿಟಿ ಬೇಕಾ?
ಅಲ್ಲ, ಅವರು ಪೂರ್ ಫ್ಯಾಮಿಲಿ ಮೇಲೆ ಅವ್ರ ಕಡೆ ಯಾರು ಇಲ್ಲ ಶ್ಯೂರಿಟಿ ಕೊಡೋದು.
ಬೇಕಾಗಿಲ್ಲ, ಅದ್ ಯಾಕೆ ಬೇಕು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಹಾಗೆ ಅಡ್ವೊಕೇಟ್ ಇಟ್ಕೋಕ್ ಎಂಗೇಜ್ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಇತ್ತಲ್ವಾ?
ಪ್ರೊವೈಡ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅವರು ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅಫಿಡವಿಟ್ ಮಾಡಿ.
ಯಾರು ತಗೊಂಡಿಲ್ಲ? ಅದ್ರ ಬಗ್ಗೆ ಡೀಟೇಲ್ಸ್ ಬೇಕಲ್ಲ, ಅವ್ರು ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ? ಯಾರು ತಗೊಂಡಿಲ್ಲ? ನೀವು ತಗೊಂಡಿಲ್ವಾ? ಅವ್ರು ತಗೊಂಡಿಲ್ವಾ?
ಇಲ್ಲ, ಅಕ್ಯೂಸ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಅಕ್ಯೂಸ್ ತಗೊಂಡಿಲ್ಲ?
ಹೌದು ಸರ್.
ಯಾವ ಕಾರಣಕ್ಕೂ?
ಅದ ಮೇನ್ ರೀಸನ್ ಬಂದು ಶ್ಯೂರಿಟಿ ಪ್ರಾಬ್ಲಮ್, ಮತ್ತೆ ಅವರು ಆಗ್ತಾನೆ ಕನ್ವಿಕ್ಷನ್ ಆಗಿತ್ತು.
ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಕೊಡ್ತಾರೆ, ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾರೆ, ಅವ್ರು ಮಾಡ್ತಾರೆ, ಶ್ಯೂರಿಟಿ ಬೇಕಾಗಿಲ್ಲ.
ಹೌದು ಸರ್.
ಅದನ್ನ ಯಾಕೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರಿ?
ಅಕ್ಯೂಟ್ ನ ಕೇಳಿದ್ರೆ ಆತರ ಹೇಳಿದ್ರು ಸರ್ ಪಿಟಿಷನರ್.
ಹೇಳಿದ್ರು ಸರಿ, ಯು ಆರ್ ಎನ್ ಅಡ್ವೊಕೇಟ್, ಯು ಶುಡ್ ಎನ್ಕ್ವೈರ್. ಅವ್ರು ಹೇಳಿದ್ದನ್ನ ಬಂದು ಇಲ್ಲಿ ಹೇಳೋದಕ್ಕೆ ಪೋಸ್ಟ್ ಮ್ಯಾನ್ ನೀವು?
ಇಲ್ಲ ಮ್ಯಾಮ್.
ಮತ್ತೆ ಯು ಶುಡ್ ಎನ್ಕ್ವೈರ್. ವಾಟ್ ಈಸ್ ದ ರೀಸನ್ ಟು ರಿಜೆಕ್ಟ್? ಅದಕ್ಕೆ ಅಲ್ವಾ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ದು ಬೆಟರ್ ಅಫಿಡವಿಟ್ ಹಾಕಿ ಅಂತ.
ಹೌದು ಸರ್.
ದೆನ್ ಇವತ್ತು ಬಂದು ಅಷ್ಟೇ ಹೇಳಿದ್ರೆ? Even in this application, there is no reasons assigned as to why the appellant has refused. Why the appellant has unable to appoint the advocate when according to him the jail authority has provided legal services. Counsel for the appellant prays for time. Next.
Serial number 21, N.S. Sampangi Ramaya.
Filed an IA for delay of condemnation, my lord, 108 days delay in filing.
Third one, counsel for the appellant on IA 1 of 2025 seeking condemnation of delay of 108 days in preparing the appeal for the reasons stated also. IA 1 of 2025 is allowed delay of 108 days in preparing the appeal is condoned. Next, third, on IA 2 of 2025 seeking suspension of sentence and for enlarging the accused on bail. Yes, he was on bail.
No, my lord, he was not on bail.
He was not
Records
on bail.
ಬಂದ್ಬಿಡ್ಲಿ ಸ್ವಾಮಿ, because
Accused is in
POCSO is
custody.
there.
Third is also
POCSO is
on IA
there.
2 of 2025. It is noticed that the appellant was, and the serious allegations are made against the appellant, and he was in judicial custody even during trial. The accused is convicted as per the impugned judgment, convicted and sentenced as per the impugned judgment. Under such circumstances, I do not find any reason to allow IA 2 of 2025. Accordingly, IA 2 of 2025 rejected. IA 2 rejected, IA 1 allowed, delay condoned, admit, heard so and so, admit.
The liberty to move after the records have come.
Call for trial court records.
With the liberty to move after the records have come.
Noted, ಅದು ಬರ್ಲಿ.
Obliged.
ಅನುಕೂಲ argument. Next.
Serial number 22, Dilraj Rohit.
Appellant by me. My lord, Section 6 of the POCSO Act, my lord, conviction for 20 years.
ಅದು
Condonation of delay is there.
First, HCGP to take notice for responding number so and so. Heard on IA 2 of 2023 seeking condonation of delay of 32 days in preparing the appeal for the reasons stated in so and so. IA 2 of 2025 is allowed, delay of 32 days in preparing the appeal is condoned. Heard on IA 1 of 2025 seeking suspension of sentence and to release the appellant on bail. Yes, whether he was on custody, whether he was in.
My lord, he was in custody, my lord, no bail application was filed at all.
Then argue the matter. I will admit this and call for trial court records. You argue the matter.
In the meantime, my lord,
1 of 2023 dismissed. ಮೇಲಿಂದ ಹೇಳಿದಿವಲ್ಲ. This appellant being accused number 1 was in custody even during trial and he is convicted and sentenced as per the impugned judgment. I do not find any reason to so and so. Heard so and so, admit, call for trial court records. Is to notice ಬೇರೆಯವರು ಇದ್ರೆ I should notice. Call for trial court records. Yes. Call for trial court records. IA 2 is allowed, 1 is dismissed. Next.
Serial number 23, Chaudhary HR.
For appellant, madam, is a victim appeal composition, for composition appeal, madam.
Victim.
Victim.
Appellant.
appellant.
ಏನ್ ಪ್ರೇಯರು?
Prior composition of the victim composition, my lord, is a very low, the pass the order, my lord, in sessions court. Delay for 117 days, but state is a, prayer is only against the state, my lord. It's a
You have
respondent
to
number
approach
2.
the legal services authority ಅಲ್ವಾ, appeal ಹಾಕ್ಬೇಕು.
Without court order, my lord, is not.
Without court order, the authority is authorized.
No, my lord, is
ಸ್ಕೀಮ್ ಇದೆಯಲ್ಲ, ವಿಕ್ಟಿಮ್ ಕಾಂಪನ್ಸೇಷನ್
ಹೌದು,
ಸ್ಕೀಮ್ ಇದೆ.
ನಾನು ಅದ್ರ ಮೇಲೆ ಹಾಕಿರೋದು, ಬಟ್
ಅದ್ರ
ಇಲ್ಲಿ
ಮೇಲೆ appeal
ಏನಾಗಿದೆ,
ಹಾಕ್ಬೇಕು.
ಒನ್ಸ್ ಇಸ್ ಆಲ್ರೆಡಿ ಪಾಸ್ ದಿ ಆರ್ಡರ್, ಅದ್ರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇಷ್ಟೇ ಕೊಡಿ ಅಂತ.
ಯಾರು?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇನ್ ಪೇಜ್ ನಂಬರ್ 75.
You are seeking enhancement.
Enhancement.
Heard and counsel for the appellant. First, CGP takes notice for so and so. Heard so and so. And I 1 of 22 was seeking condonation of delay of 117 days. It is noticed that the victim, or the
R2.
complainant,
Complainant.
victim
R2 is a formal party. Against the R2 is no prayer.
preferred this appeal, seeking enhancement of compensation awarded in his favor. For the reason stated in so and so, IA 1 of 2025 is allowed. Delay of 117 days in preferring the appeal is condoned. Issue notice. Next. Issue notice.
R2 is a formal party.
Yaru, who is R2?
Accused my lord.
Or
Conviction.
Bedwa?
ಏನು ಅವ್ರ ಮೇಲೆ ಏನು ಪ್ರೇಯರ್ ಇಲ್ಲ ನಾನು.
Are you seeking dispensation?
Dispense.
Counsel for the appellant seeks dispensation.
R2.
Notice to respondent number 2. Permission is placed on record. Notice to respondent number 2 is dispensed with. Yes. Next.
Please.
Number 24, Kumar Nanjundagowda.
Appellant malay. Conviction under section 6 of POCSO Act malay. Prison for 20 years malay. Delay application.
CGP to take notice for respondent number so and so. Heard IA 1 of 2026 seek condonation of delay of 106 days in preparing the appeal. For the reason stated in so and so, IA 1 of 2025 is allowed. Delay of 106 days in preparing the appeal is condoned.
Kindly call for LCR malay.
Heard so and so, and I admit. ಮತ್ತೆ respondent idara, issue notice so and so. Call for trial court records. Yes, admitted.
Please.
Serial number 25, adjourned. 26, Krishnegowda M.
CGP to take notice for respondent number so and so. Heard on IA 1 of 2025 seeking condonation of delay of 53 days in preparing the appeal. For the reason stated in so and so, IA 1 of 2025 is allowed. Delay of 53 days is in preparing the appeal is condoned. Heard on IA 2 of 2025 seeking suspension of sentence. He was on bail.
Please, my lord.
When is it?
In page number 9, my lord. Page number 9, my lord. In my petition, my lord.
Page number 9 ನಿಮ್ದಾಯ್ತು, judgment ಅಲ್ಲಿ.
My lord, after judgment, my lord, we
Release
file
of
an
the
application
accused.
under section
Release
389
ಆಗಿದಲ್ಲ?
class 3, my
Bail
lord.
ನಲ್ಲಿದೆ. ಆಗಿತ್ತು. Appellant was on bail during trial.
Session court ಅಲ್ಲಿ 389 class 3 ಹಾಕಿದ್ವಿ, ಅದರಲ್ಲಿ bail ಆಗಿದೆ, surety ನು furnish ಮಾಡಿದ್ವಿ sir.
Suspension of sentence. He is in custody.
No, my lord, he is outside, my lord.
Order of sentence is suspended.
Sentenced for 363 plus
Call for
363 of CRPC, my lord.
issue notice. Yes. IAs are allowed, admitted. Call for trial court records,
Please.
issue notice. Next.
Much obliged.
Serial number 27, Varadaraj Rangnath.
ಏನು ಬರಲ್ಲ ರೀ.
In my opinion, order 47 should be scrapped. I was going through a judgment of the apex court, my lord. They have reversed the judgment of the earlier bench who had all retired.
ಏನ್ ಮಾಡೋದು?
My lord, I made some verification and all these things. Could you give me just 2 days time, my lord? Just 2 days time.
ಅಲ್ಲ, it will not help you in any manner.
ಅಲ್ಲ ಸ್ವಲ್ಪ ಇದೆ. ಮಾಡ್ತೀನಿ
I have gone through
ಇಲ್ಲ
the-
ಮಾಡ್ತೀನಿ just give me 2 days time my lord.
2 days ಆಗಲ್ಲ, next week ಯಾವಾಗಾದ್ರೂ ಅಷ್ಟೇ. Counsel for the petitioner, prays for time. ಅಷ್ಟೇ ನೋಡಿ, no purpose would be served on
24th ಗೆ ಹಾಕೊಂಡ್ರೆ ಮಾಡ್ತೀನಿ.
24th ಇಲ್ಲ ಸರ್, ಲಾಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ, ರೋಸ್ಟರ್ ಎಂಡ್ ಆಗ್ತಾ ಇದೆ, ಸೊ ಮೇ ನಾಟ್ ಬಿ ಪಾಸಿಬಲ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಲ್ಲಿ. ಎಸ್
Further hearing, user number 28, KC Nitin Gowda.
only accused number 4.
Yes. Lords, insofar as this accused number 4, you may be permitted to, my lords, reiterate the exact overt act as per the prosecution. Lords,
He was on the backside of the home.
Yes. To that extent, my lords, no witnesses would depose anything on that. One, nobody has identified me. Third, ಅಲ್ಲ ನಾನು ಏಕೆಂದ್ರೆ
incriminating
yes,
materials.
incriminating, my lords, your lordships were, my lords, keen to indicate that, my lords, one of the witnesses would identify me while recovering the article.
W10.
Yes.
Exhibit.
Exhibit P5. Yes, these are, my lords, for that.
What was recovered?
It was a joint recovery at the behest of accused number 1 to 6, and exhibit P6 would indicate that, my lords, it was taken out from A2 at the behest of A2, not, my lords, the appellant. And in order to substantiate that, my lords, prosecution claims that house belongs to accused number 4. The very next witness, PW11, is the house owner. He says, I have never rented out that particular.
Why his version is to be believed?
My lords, because prosecution has not placed a single piece of paper to indicate, my lords, my dominion over, my lords, that house. That is one. Secondly,
What was recovered?
lords, golden articles, my lords, 82 gold articles, one box, one mobile phone, the broken mobile phone, one lock, and 4,000 cash. No, my lords, may I request the court to, my lords, kindly take the very exhibit itself, my lords. The very exhibit itself would specifically indicate that, my lords, it is a joint recovery at the behest of all accused persons, not just me. Lords, the third paragraph of the Mahazar. I just read, my lords. ನಾವು ಮತ್ತು ಪೊಲೀಸ್ ಆರೋಪಿಗಳನ್ನು, ಪೊಲೀಸರು ಆರೋಪಿಗಳು.
ಯಾವ ಆರೋಪಿಗಳು?
Lords,
All the
accused. ನಾವು ಮತ್ತು ಪೊಲೀಸರು ಆರೋಪಿಗಳೊಂದಿಗೆ ಖಾಸಗಿ ವಾಹನದಲ್ಲಿ ಈ ಮೇಲ್ಕಂಡ ವಿಳಾಸಕ್ಕೆ ಹೋಗಿದ್ದು, ಆರೋಪಿಗಳೆಲ್ಲರೂ ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ಸ್ ಆರೋಪಿಗಳೆಲ್ಲರೂ ಮೇಲ್ಕಂಡ ಮನೆಯನ್ನು ತೋರಿಸಿ ಇದೇ ಮನೆಯಲ್ಲಿ ಮಾಲುಪಟ್ಟಿ ಇಟ್ಟಿರುವುದಾಗಿ ನುಡಿದು ಆರೋಪಿ ಶ್ರೀನಿವಾಸನಿಂದ ಮನೆ ಬೀಗ ತೆಗೆಸಲಾಯಿತು. So, my lords, my role is I have unlocked the door.
So if you are not in possession, how can you unlock the?
I will, I'll answer that point. Kindly see, my lords, the next sentence. ನಂತರ ಆರೋಪಿಗಳೆಲ್ಲರೂ ಅಡುಗೆ ಮನೆಯ ಸೆಲ್ಫ್ ಮೇಲೆ ಇಟ್ಟಿದ್ದ ರಟ್ಟಿನ ಬಾಕ್ಸ್ ತೋರಿಸಿದರು. Again, my lords, all accused would indicate. ತೋರಿಸಿದ್ದು. ನಂತರ ಆರೋಪಿ ರವಿಯು, this Ravi is A2. Against him, the allegation is that, my lords, he in fact, my lords, entered the house, committed dacoity. He bit the finger of the complainant, made him, my lords, sustain bleeding injury. Even ಮೇಲೆ ಇಷ್ಟು serious allegation ಇದ್ರೂ, he himself, my lords, takes out the retina box. He says, ಸದರಿ retina box ಅನ್ನು ತೆಗೆದು, accused number 2, my lords, Ravi. He's been, my lords, granted the benefit of acquittal. ರವಿಯು ಸದರಿ ರೆಟಿನಾ ಬಾಕ್ಸ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡು ಬಂದು ಪೊಲೀಸರ ಮುಂದೆ ಹಾಜರು ಪಡಿಸಿದನು. So this would indicate that, my lords, this is a joint recovery, not just, my lords, incriminating only against, my lords, the appellant.
Yes.
Now, secondly, my lords, this particular, my lords, recovery itself is, my lords, flawed and, my lords, not in consonance with, my lords, the directions of the Honorable Apex Court. Just, my lords, may I invite the court's attention to one judgment, my lords, of the Apex Court. Just place it on record, my lords. Lords, Babu Saheb Gowda, 2024, Part 8, SCC 149. how, my lords, a voluntary statement and a recovery has to be made. That's discussed in this case. In this case, my lords, none of the, my lords, directions of the apex court, my lords, has been followed. May I invite the court to, my lords, to para 66. Paragraph 66, your lordships will find at, my lords, page 21 at the top left page number. Para 66, my lords. May I read, my lords? The 78, my lords, is the extract of, my lords, one judgment. 78 and the shura. May I read, my lords? If it is say of the investigating officer that the appellant accused, while in custody on his own free will and volition, made a statement that he would lead to the place where he had hidden the weapon of offense, the site of burial of the dead body, clothes, etc., then the first thing that the witnesses at the first thing that the investigating officer should have done was to call for two independent witnesses at the police station itself. Once the two independent witnesses would arrive at the police station, thereafter, in their presence, the accused should be asked to make an appropriate statement as he may desire in regard to pointing out the place where he is said to have hidden the weapon of offense, etc. This is, my lords, the first part. This is not done in this case. Yes. Then, when the accused, while in custody, makes such statement before the two independent witnesses, such the punch witnesses, the exact statement, or rather the exact words uttered by the accused, should be incorporated in the first part of the Panchanama that the investigating officer may draw in accordance with law. This is also, my lords, not done in this case. Then, this first part of the Panchanama for the purpose of section 27 of Evidence Act is always drawn at the police station in the presence of the independent witnesses so as to tend credence that a particular statement was made by the accused expressing his willingness on his own free will and volition to point out the place where the weapon of offense or any other article in commission of offense had been hidden. Yes. Then, your lordship, once the first part of the Panchanama is completed, thereafter the police party along with the accused and the two independent witnesses would proceed to the particular place as may be led by the accused. If from the particular place anything like the weapon of offense or bloodstained clothes or articles is discovered, then that part of the entire process would form the second part of Panchanama. This is how the law expects the investigating officer to draw recovery Panchanama as contemplated under section 27 of Evidence Act. That's, this, my lords, is how, my lords, the voluntary statement and, my lords, recovery ought to have been, my lords, done in, my lords, not just this case, my lords, in every other case. Voluntary statement. My lords, one other aspect I want to brush upon is, my lords, if at all there were to be, my lords, a voluntary statement, there has to be, my lords, one express of, my lords, willingness, voluntariness, that is one part. Second part, there has to be, my lords, a description of the property that he would indicate, my lords. In this case, my lords, nothing has been stated. They just said, now darode madidivi, mane darode madiro item na toristhi. This is, my lords, not one or two items that has been recovered. 82, my lords, gold articles are recovered. Not one description of an item has been, my lords, stated in any of, my lords, the voluntary statements of all the accused. Exhibits 28 in the 34, my lords, are marked. These are, my lords, voluntary statements.
Yes.
None?
What is it? Not in accordance with law. That yes, PW
11 minutes. Is hostile minutes.
But it was produced by accused number 2. Role of accused number 2. Accused number 4 is only to open the door. Joint recovery gelli the statement in. And the other accused were given benefit of doubt. They were already acquitted. He is also entitled. So, ಇದು ಮೊದಲು ಆಗಿದೆ ನೋಡಿ ಅದರದ್ದು co-accused ಇದು ಇದಾಗಿದೆ. ಇದನ್ನೆಲ್ಲ ತಗೊಳ್ಳಿ. ಇದರಲ್ಲಿ ಬೇಕಾಗೋದೊಂದು ಎಕ್ಸ್ಟ್ರಾ ಹೇಳ್ತೇನೆ ನಾನು ಅಷ್ಟೇ. According to the case made out by the prosecution, Exhibit P5 is the recovery measure drawn in the presence of independent witnesses, according to which a box containing 82 gold ornaments were recovered at the joint instance of accused number 126. It is stated that the said house was in possession of accused number 4. He was the lessee in occupation of the same. The Mazda states that it was accused number 4, the appellant hearing, who opened the door with the help of a key. But it is pertinent to note that as per Exhibit P5, all accused number 1 to 6 have led the police to show the house. It was accused number 2 who, accused number 1 to 6, who have showed the box kept in the kitchen, and it was accused number 2 who removed the box and produced the same before the investigating officer to recover the incriminating materials. PW11 is the owner of the said house, who is supposed to state that he had leased out the premises in favor of accused number 4. But the said witness has not supported the case of the prosecution, nor deposed that he has let out the premises in favor of accused number 4. No other documents are available to connect accused number 4 to the offense in question under such circumstances under vide. Moreover, it is the contention of the prosecution that all accused number 1 to 6 have given the voluntary statement, voluntarily disclosing and leading the investigating officer to the place in question. The counsel for the appellant has placed reliance on the decision of the apex court in Babu so-and-so 2024 8 SCC 149 in support of its contention that none of the requirements of Section 27 of Indian Evidence Act is complied with. The apex court, while considering the requirement of Section 27 of Evidence Act, refer to the decision in Subramania vs. State of Karnataka 2023 Part 11 SCC 255 and extracted para 76 to 78, which reads as under 78 Act of para number 66, which reads as under para 67 of the judgment in Babu Hevagowda Rudragowda also reads as under. In the present case, admittedly, the so-called voluntary statement given by either accused number 4 or any other accused are produced. It is not in dispute that the co-accused who have preferred criminal appeal number 103, 109 and 147 of 2013 are acquitted by allowing those appeals with a judgment dated, common judgment dated 15/7/2025. Under such circumstances, I am of the opinion that the appellant being accused number 4 is also entitled for the benefit of doubt to acquit him of the offense alleged against him. Accordingly, I answer the point. Allowed.
Grateful for the opportunity.
ಅದನ್ನು ಫೀಸ್ ಬರ್ಕೊಂಡು ಅದು ಹಾಕೊಂಬಿಡಿ. Registry is direct. Pay the fees of rupees 10,000 to the learned amicus curiae. Yes.
Serial number 29, Sandesh Nadigar, Jay Prakash Reddy.
Yes,
SCR records are awaited, Manoj.
records are received.
Manoj, they kindly pass out. Manoj. Council on record will come and submit.
Pass over.
Serial number 30. Vijay and Desai.
Counsel for the appellant is absent, no representation. Accordingly, order sheet dated so and so. 2/7/2027, 25, under. In spite of that, there is no representation. It is clear that the appellant and his counsel are not interested in addressing the argument. Hence, so and so is appointed as amicus curiae. Otherwise, the hakul. Amicus curiae. Yes, next. Otherwise, hakul. Next.
Serial number 31. Ramesh Kumar, Umesh PB, amicus curiae.
Offense is, my lord, 399, 401, my lord. There are connected matters there, my lord. Criminal appeal 201/2012. It was allowed on, my lord, on 26/10/2023, my lord, page number 95 of the. There are 5 accused are there, my lord.
Connected criminal appeal is allowed.
Allowed, my lord. Page number 95A, my lord. There are 5 accused are there, my lord. So far as this petition, this appellant is concerned, my lord, is the A5.
In all, 1 to 5.
1 to 5, my lord.
This appellant is A5.
A5, my lord.
What about A?
1 to 4 are the acquitted, my lord. Kindly see the page number 95, my lord. But, my lord, in the order, my lord, in the operative portion of the order, my lord, though there are 4 appellant is there, my lord, but in the operative portion of the order, my lord, the accused number 1 to 5 are the acquitted. That is the observation made by the honorable judge, my lord.
Yes. Similar allegations against all the accused. Making preparations. Accused number 1 to 4 are already acquitted, extending the benefit of doubt. No separate word act. Accused number 5 will appellant.
A5, my lord.
Accused number 5.
A5, my lord. And also, my lord, in the order sheet, order of the, in the page number 16C, my lord. 16CLU, sir. 16CLU. Trial court has observed also accused number 1 to 16C, my lord.
Accused number 5. In SC 234 of 2010 on the file of First Track Court 2 at Mysore is impugning the judgment of conviction and order of sentence dated 28/1/2012, convicting and sentencing him for the offence punishable under section 399 and 402 of IPC and sentencing. First he convicting and thereafter sentencing. So and so. Case of the prosecution in brief is that on 8/11/2009, PW5 received credible information at about 7:45 p.m. about 5 persons made preparations and assembled behind Bannada Nagara Balli Mantapa B layout on the ring road at a distance of 100 meters from the railway bridge for the purpose of committing dacoity. PW5 was in the police station has proceeded to the spot along with Mahazar witnesses and could apprehend them. And under the Mahazar, the longs, clubs, chili powder, Maruti Omni car, Maruti Omni van were recovered. And therefore it is contended that the accused have committed the offence punishable under section 399 and 402 of IPC. Prosecution examined how many witnesses?
There are only 5 witnesses, my lord.
Only 5.
5, my lord.
PWs 1 to 5 got marked exhibit P1 to 5 in support of its contention. The learned magistrate took cognizance of the offence and committed the matter to the Sessions Court. The trial court summoned the accused. The accused has appeared before the trial court, pleaded not guilty and claimed to be tried. The prosecution examined PWs 1 to 5, got marked exhibit P1 to 5 in support of its contention. The appellant has denied all the incriminating materials available on record, but has not chosen to lead any evidence in support of his defense. The trial court, after taking into consideration the materials that are placed before the court, came to the conclusion that prosecution is successful in proving the guilt of the accused beyond reasonable doubt. Accordingly, the impugned judgment of conviction and order of sentence was came to be passed. The appellant, being accused number 5, is before this court, seeking to set aside the impugned judgment of conviction and order of sentence. Also, perused and for consideration, my answer to the above point affirmative for the following reasons. It is the contention of the prosecution that accused numbers 1 to 5 have made preparations and were armed with longs, clubs, chili powder, plastic rope, a torch, and assembled at the scene of occurrence with a Maruti Omni van, and they have made preparations for committing dacoity. On receiving credible information by PW5, the PSI of Narsimharaja Mohalla Police Station on 8/11/2009 at 7:45 p.m. She went to the spot along with the Mahazar witnesses, found accused number 1 to 5 with the Maruti Omni car bearing registration number CKQ 38332, and was satisfied that the accused have assembled there by making preparations to commit dacoity. PWs 1, 2, and 4 are the police officials who accompanied accused PW5, and PW3 is the Mahazar witness. PW3 has not supported.
PW3 the mother supported, madam.
Supported.
It is there, madam. It is supported.
All these witnesses have supported the case of the prosecution. However, immediately after receipt of the credible information by PW5 regarding assembly of the accused with an intention to commit dacoity, the same was not recorded in the diary, but PW5 along with her staff, PWs 1, 2, and 4, along with PW3 went to the spot and apprehended accused number 1 to 4, seized the incriminating materials. No incriminating materials were marked. MOs ಯಾವುದು ಇಲ್ಲ.
MOs madam.
ಯಾಕೆ? ರೀಸನ್ ನೋಡಿದ್ರೆ ಏನು ಅಂತ ಇಲ್ಲ.
Copy.
Why no MOs are marked? Strangely, even the incriminating materials were not identified as material objects to substantiate the contention of the prosecution. Expert. It is brought to the notice of the court that accused number 1 to 4 have preferred criminal appeal number 201 of 2012. The coordinate bench of this court, with a judgment dated 26th October 2023, allowed the appeal and acquitted the accused number 1 to 4. However, in the operative portion of the order, the judgment of the trial court passed against accused number 1 to 5 was set aside, and all of them were acquitted. Pendency of the present appeal preferred by accused number 5 was not brought to the notice of the coordinate bench of this court. Next paragraph. The allegations made against accused number 1 to 5 are similar. No separate overt act is alleged against the present appellant accused number 5. The coordinate bench of this court found that there is a discrepancy in the evidence of the prosecution witnesses with regard to seizure of the material objects. It has also commented as to why the credible information received by PW5 was not recorded in the station house diary. It found that the case of the prosecution regarding commission of the offense by the accused cannot be accepted without reasonable doubt. Under such circumstances, benefit of doubt was extended to the accused to acquit them. When the co-accused against whom similar allegations are made are already granted or acquitted, I do not find any reason to, I do not find any justification to confirm the judgment of conviction. The present appellant being accused number 5 is also entitled for the benefit of doubt and to be acquitted. Accordingly, I answer the report. Allowed. Fees registry, legal aid. Secretary, High Court Legal Services Committee is directed to pay. Yes, next. 10.
Serial number 32, Arjun. 33, Miss Salma.
Your Lordship. Convicted for POCSO, Your Lordship. Here, convicted for section 6 of POCSO, Your Lordship.
You are representing whom? Nanjunde Gowda?
Appellant, Your Lordship. Accused. Umme Salma, Your Lordship.
ಅವರು ವಕಾಲತ್ ತಗೊಳ್ಳಿ ಒಂದು ನಿಮಿಷ. Learned counsel Sri Nanjunde Gowda MR has filed a memo seeking permission to retire from the case. Learned counsel Sri Umme Salma has filed wakalat with NOC from the earlier counsel. Hence, learned counsel Sri Nanjunde Gowda is permitted to retire. Office is directed to delete his name in the cause list. Good.
Appellant is convicted for POCSO Act, Your Lordship.
Sole
section
accused?
Sole accused, Your Lordship. Here, only thing I'm seeking is set of the this thing, Your Lordship. Period undergone, Your Lordship. He has been convicted for 10 years. He has undergone 6.5 years, Your Lordship.
6.5 years already undergone.
Yes, Your Lordship.
You are not on merits of the case.
No, Your Lordship.
He was in custody during trial.
Yes, Your Lordship. Yes.
What is the sentence?
10 years, Your Lordship. 104, page 104, Your Lordship.
Section 6. 448, 376.
376-2, he is not convicted, Your Lordship.
Huh?
He has not been convicted for 376-2, Your Lordship.
No. Accused is hereby convicted for the offense 448, 376-2N, 420
Your
of
Lordship,
IPC.
page 104.
Section
Since
6.
punish 104, page 104.
ಅದು ಮರ್ಜ್ ಆಗುತ್ತಮ್ಮ 42 of POCSO Act.
Yes, Your Lordship.
Minimum sentence is 10 years.
Yes, Your Lordship.
He has to undergo another 3.5 years. Minimum sentence under section 6 is 10 years. Alva? Yaವಾಗ date of offense?
21/3/2019, Your Lordship. Your Lordship, date of
21/3.
offense they have not given. Complaint is after 5 months, Your Lordship.
No, date of offense is 21/3.
2019 is the complaint. Offense they are stating before 5 months. The offense was before 5 months. No date is given in the complaint, Your Lordship.
So 10 years. Minimum 10 years. I will confirm the judgment. He is entitled for set off first.
Your Lordship, no documentary evidence, no eyewitness, Your Lordship. No
You should
eyewitness.
understand the minimum sentence
Yes,
for
yes,
section
I-
6 is 10 years.
10 years.
We cannot impose the lesser sentence.
Imposing fine.
Huh?
Your Lordship, imposing fine, increasing the fine. Or
ಎಲ್ಲಿದೆ section 6 read section 6.
It's not there.
ಕೊಡಿಯಲ್ಲಿ. When minimum sentence is prescribed,
Who are commits a
ಎಷ್ಟಿದೆ?
minimum is less, 20 years more. Your Lordship.
20 years. ಇಲ್ಲಿ 10 years ಕೊಟ್ಟಿದ್ದಾರೆ. Looking to the date of offense. So ಅದಕ್ಕಿಂತ ಇದು ಬರಲ್ಲ, ಅದನ್ನೇ ಕನ್ಫರ್ಮ್ ಮಾಡೋಣ. Is entitled for set off first. ತಗೊಳ್ಳಿ. Who are the material witnesses? Who is PW1?
Father of the
Complainant.
complainant is father of the victim.
He filed the complaint.
Yes, Your Lordship.
Who is PW2?
Victim.
Victim. PW3?
Brother of the victim.
PW4? Doctor?
Doctor. Yes. Medical
Examine the
officer.
victim. PW5?
Mazer witness.
Which Mahazer?
Sunil, yes.
Huh? Exhibit P2. Then PW6. Doctor examined the accused. Then PW7. Exhibit PW8. ಹಾ ಏನ್ ಕೊಟ್ರು? ಎಕ್ಸಿಬಿಟ್ ಯಾರ ಹೆಸರಿದೆ? ಮನೆ ಸರಿ ಯಾರ ಹೆಸರಿನಲ್ಲಿದೆ? ಫಾದರ್ ಆಫ್ ಹೌದಾ? ನೋಡಿದೀರಾ? ಸುಮ್ಮನೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಗೊತ್ತಿದೆ, ಅದಕ್ಕೆ ಕೇಳ್ದೆ ನಾನು. ಈಸಿ ಏನಾರು ಒಂದು ಕೇಳಿದ ಕೂಡಲೇ ಏನಾರು ಒಂದು ಹೇಳ್ಬಿಡು. ಹಾ ಹೂ ಇಸ್ ಮನಿ ವೆಂಕಟಮ್ಮ? Who is PW9? Examine the accused. PW10.
Headmaster.
ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಹಾ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಸ್ಕೂಲ್ ಅಡ್ಮಿಷನ್
TC ಅಲ್ಲ, ಟ್ರಾನ್ಸ್ಫರ್ ಸರ್ಟಿಫಿಕೇಟ್.
ಅಪರ್ಚುನಿಟಿ ಬಂದ್ರೂ ಕೂಡ ಪ್ರಿಪೇರ್ ಆಗೋದಿಲ್ಲ ನೀವು ಇಬ್ರು, ಏನೂ ಗೊತ್ತಿಲ್ಲ. ದಿಸ್ ಇಸ್ ದಿ ವೇ ಆಫ್ ಪ್ರಿಪೇರಿಂಗ್ ಫಾರ್ ಎನ್ ಆರ್ಗ್ಯುಮೆಂಟ್. Then PW11.
Women police constable.
ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಸ್ಪಾಟ್ ಮಾಜರ್. PW12.
Independent witness, your lordship. Independent witness, your lordship. 12 independent witness, your lordship.
ಏನ್ ಹೇಳ್ತಾರೆ? ಇಂಡಿಪೆಂಡೆಂಟ್ ಸರಿ.
Identified the signature, your lordship.
Signature of whom?
Of the signature. Turned hostile 12, 13, 14.
13.
Same. Same, your lordship. 12, 13, 14. Same.
15.
Woman police constable deposed about escorting the victim for medical examination.
16.
Doctor.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Radiologist. Radiologist, your lordship. Doctor.
ಯಾಕೆ?
Scanning of the.
ಯಾಕೆ ಸ್ಕ್ಯಾನಿಂಗ್ ಮಾಡಿದ್ರು?
5 months pregnant. She was 5 months pregnant.
PW 17.
Independent witness. Independent witness
ಏನ್ ಹೇಳ್ತು?
deposed about the receiving the complaint. Deposed about the receiving the complaint, Your Lordship. On 20.
Then
On 21/3/2019.
PW 18.
Investigating officer IO.
File charge sheet.
Yes.
PW 19.
Doctor who has examined DNA. Doctor, Your Lordship.
DNA.
DNA and blood test.
DNA ಏನಾಗಿದೆ? P23. It's matching. The accused in SC 106 of 2019 on the file of the Learned Second Regional District and Sessions Judge Kolar is impugning the judgment of conviction and order of sentence dated 10th November 2020, convicting him for the offence punishable under sections 420, 448 of IPC and 376
Your Lordship, they have not produced the school date of birth, Your Lordship. Only TC they have produced.
448, 376 to N, 420 of IPC and under section 6 of POCSO Act, and sentencing him to undergo rigorous imprisonment for so and so 448, 420 and under section 6 of POCSO Act. Case of the prosecution in brief is that the victim PW2 was aged about 17 years. The accused has trespassed into her house, committed forcible sexual intercourse, repeatedly under the pretext of marrying her. And thereby committed the offence. Later, he refused to marry her and thereby committed the offence punishable under section 420 of IPC. The investigating officer completed the investigation and filed the charge sheet for the aforesaid offence. The learned magistrate took cognizance of the offence and summoned the accused. The accused has pleaded not guilty and claimed to be tried. Prosecution examined PWs 1 to 19, got marked exhibit so and so, exhibit P1 to 30 in support of its contention. The accused has denied all the incriminating materials available in the court but has not led in evidence in support of his defense. Trial court, after taking into consideration all these materials on record, came to the conclusion that the prosecution is successful in proving the guilt of the case beyond reasonable doubt. Being aggrieved by the same, the appellant is before this court. Heard so and so. Very material. Point for consideration. My answer to the point in the negative for the following reasons. It is the specific contention of the prosecution that the accused aged 24 years illegally trespassed into the house of the victim girl, aged 17 years, committed penetrative sexual assault, sexual intercourse repeatedly under the promise to marry, and later refused to marry her. PW1, the father of the complainant, logged the first information on 21/3/2019, alleging commission of the offence and stating that the victim was pregnant. PW2, the victim, has supported the case of the prosecution. PW3 is the brother of the victim who has also deposed in support of the case of the prosecution. PW4 is the doctor who examined the victim girl and subjected her for scanning through PW16. According to the report, the victim was pregnant by 5 months. 5 months. PW5 is the Mahazar witness to this Hoffman. PW6 is the doctor who had drawn the blood samples of the victim and the accused for DNA sampling. PW7 is the assistant executive engineer who had drawn the spot sketch as per exhibit P9. ಇದನ್ನೆಲ್ಲ verify ಮಾಡ್ಬೋದು. PW8 is the PDO who issued the demand register, extract of demand register as per exhibit P11, where the incident had occurred. The said house was standing in the name of Muni Venkatama. PW9 is the doctor who examined the accused. PW10 is the headmaster of the school who issued exhibit P14 and 15 as per admission extract pertaining to the victim. The date of birth was 16/6/2002. PW11 is the police constable who has written the spot panchanama, exhibit P2. PW12 to 14 are the independent witnesses who have not supported the case of the prosecution. PW15 is the police constable who accompanied the victim for medical examination. PW17 is the carrier of the FIR. 17 is the investigating officer who registered the FIR. And PW18 is the investigating officer who completed the investigation and filed the charge sheet. PW19 is the scientific officer who has issued the DNA report as per exhibit P23. PWs 1 to 3 have categorically stated regarding the offence committed by the accused. The medical report supports the contention of the prosecution. The DNA report is as per exhibit P23. According to which the profile results of baby of the victim is consistent with having come from its mother and the accused, and the DNA sampling was matching with the DNA profile result of sample blood sent in item number 1 and 2. Thereby, DNA report confirms that the accused is the biological father. ಅದು ಒಂದು ನಿಮಿಷ ಒಪಿನಿಯನ್ ಅಂತ ಬಂತಲ್ಲ ಅದು ಬೇಡ ಮೇಲಿಂದ ಬೇಡ. As per DNA report, the victim is the biological mother and the accused is the biological father of the baby of the victim, and the blood samples were matching with the DNA profile result. Even though the material witnesses are cross-examined at length, nothing has been elicited from them to disbelieve their version. There is absolutely no reason to disbelieve the version of the victim PW2. The medical records produced as per Exhibit P6, P5, 6, and Exhibit P23, which clearly establishes the guilt of the accused beyond reasonable doubt. Next, the prosecution also examined PW10, the headmaster of the school, who deposes about Exhibit P14 and 15, the admission extract pertaining to the victim and the declaration made by PW1. As per Exhibit P14, the date of birth of the victim was 16/6/2002. The first information was deemed to be lodged on 21/3/2019, and it is the contention of the prosecution that by that time the victim was pregnant by 5 months. Under such circumstances, the victim was about 17 years at the time of commission of the offense. Under such circumstances, I do not find any reason to suspect the contention taken by the prosecution. Hence, I hold that the prosecution is successful in proving the guilt of the accused beyond reasonable doubt. For the offense punishable under section 448, 420, 476 to N of PC and under section 6 of POCSO Act. In view of section 42 of POCSO Act, the accused could be sentenced. Accused is liable for sentence for the offense under section 448 and 420 of IPC and under section 6 of POCSO Act. I have gone through the impugned judgment of conviction and order of sentence passed by the director. It has taken into consideration all the materials on record and imposed a minimum sentence. I do not find any reason to interfere with the same. Hence, I answer the above point in the negative and proceed to pass the following. Dismissed. Yes. Dismissed.
Serial number 34, Fayaz Saab, Javide Amicus Curie.
Appearing for the appellant, my lords. The appellant has been convicted for the offences punishable under section 6 of POCSO, my lord, for 10 years, my lord, and under section 366 of IPC for 3 years, my lords. The prosecution has examined 14 witnesses, my lord.
One. How many witnesses?
14 witnesses, my lord.
14 or 12?
Sorry, my lord, 12 minutes.
Hmm.
No, my lord, 14 minutes.
14.
Typically error, my lord, that is after 13 it's 14 minutes.
Okay.
14 minutes.
Exhibit P1 to 17.
P1 to 17 minutes.
MOS.
MOS 1 to 7 minutes.
Exhibit D1.
Portion of the statement of the victim girl minutes.
Who is PW1?
Not PW1 is the victim girl, my lord. PW2 and 3 are the parents, my lord.
Who is, PW2 is the father.
Father, my lords. 3 is the mother, my lords. And marked exhibit, and they are the exhibit P3 is the complaint, my lords.
Who filed by?
Filed by the father, my lords. And exhibit P1 and 4 are the spot mahzars, my lord.
PW4.
PW4, he's the independent witness, my lord, who has last seen the victim and the accused going on bike, my lords. 5, 6, 7 are the spot and seizure mahzar witnesses, my lord. To the exhibit P1 and 4, my lords.
PW5 is?
5, 6, 7, my lords. PW, please.
5 to 7 are?
5 to 7, my lords.
What they say?
Spot and seizure mahzar witnesses, my lord. Exhibit P1 and 4, my lords. PW8 is headmaster, my lord, who has issued school studying certificate as exhibit P7, my lords.
Date of birth?
Date of birth 28th June 2003, my lords.
PW9?
Medical officer, my lord. Examined victim, my lords, and issued exhibit P8, 9, 10, my lords, and examined MO 2 to 4, my lords.
PW10?
PW10, who has given the job for the accused in the farmhouse and provided a room, my lords.
PW11?
11 is the owner of the motorbike, my lords. MO1, my lords, motorbike. PW12 received complaint, registered FIR, my lords. PW13 partial investigation officer, my lords, and concluded and filed charge sheet by PW14, my lords.
All have supported?
My lords, here, my lords, the age, the prosecution has failed to prove the age, my
Have
lords.
supported?
1 to 4, 1 to 3, they have supported, my lord. They collaborated the evidences, my lord.
Yes.
Parents and victim girl, my lord. And my lords, the age factor, my lords, only on the conclusion, my lords, on the study certificate, my lords, the trial court has come to a conclusion that the victim girl is below the age of 18 years, my lord. Lords,
What is her age?
16 at the time of this one, my lord, 16 years.
Offense? Date of offense?
Date of offense 12/4/2019. Whether the study certificate can be considered as an evidence for the age factor, my lords, that has been appreciated by this honorable court in the division bench, my lords. Division bench of this honorable court, my lord, which is unreported judgment, my lord. Though, my lords, it has been appreciated all the judgments, my lord, even including Almela judgment, my lords. In criminal appeal number 398/2018, my lords, which is filed by the state, my lords, challenging the acquittal of the accused for the offences punishable under section 6 and 7 of the POCSO, my lords, 6 and 8, my lords, wherein it has considered the age factor, my lords, whether this document produced by the PW8 study certificate, my lord, can be in evidential and be appreciated and considered for the age factor, my lords.
What is the finding?
Lords, it has come to a conclusion that para number 16, my lords, in the said judgment, my lord.
ಎಲ್ಲಿದೆ judgment?
I will produce, my lords. Only age and the age, my lords, it has to be appreciated, my lords. And after 10 days, they have secured the victim and arrested the accused, my lord. 10 days she was with accused voluntarily, my lords. And there were no medical examination, my lord. There were no external injuries, my lords.
Injuries ಬೇಕಾಗಿಲ್ಲ.
Please, my lords. And only I'm on the point of the age factor, my lords. I'll produce the judgment, my lords, to that extent, my lords.
ಕೊಡ್ಬೇಕು ಇವಾಗ.
Send for. I'll produce in the course of that. I will.
Start dictating. ನೋಡು ಏನಾದ್ರು ಇದ್ರೆ ಕೊಡಿ, but I don't think, because the evidence of PW8 is very clear. Nothing has been elicited during cross-examination. He stated, ಪ್ರಾಥಮಿಕ ಶಾಲೆಯಿಂದ ತಂದಿದ್ದ ಶಾಲಾ ವರ್ಗಾವಣೆ ಪತ್ರದ ಆಧಾರದ ಮೇಲೆ ನೊಂದ ಬಾಲಕಿಯ ಜನ್ಮ ದಿನಾಂಕವನ್ನು ಅಡ್ಮಿಷನ್ ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ಬರೆದಿದ್ದೇನೆ.
But he is not the author of the document, but he is not the entered, my lord. Subsequently, he has been appointed, my lord.
ಅದಕ್ಕೆ ಏನು ಕ್ರಾಸ್ ಇಲ್ಲ ಸರ್. There is no cross-examination. See, PW8, only one paragraph.
Whether that study certificate should be considered or not, I will produce that judgment.
Why not? He states, ಪ್ರಾಥಮಿಕ ಶಾಲೆಯ ವರ್ಗಾವಣೆ ಪತ್ರದ ಆಧಾರದ ಮೇಲೆ ಜನ್ಮದಿನ ಅಡ್ಮಿಷನ್ ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ಜನ್ಮ ದಿನಾಂಕವನ್ನು ನಮೂದಿಸಲಾಗಿದೆ.
Please, my lord. But the admission register who has entered, my lord, he is the authorized of the said document, my
You
lord.
have never disputed that in the cross-examination. ಅಲ್ಲಿಗೆ ಮುಗೀತು ಅಷ್ಟೇ. ನಿಶಾನೆ P7 ಅನ್ನು ನೀಡಿದ್ದೇನೆ. ಆ ರೀತಿ ಹಿಂಬರಹ ಇರುವುದಿಲ್ಲ. ಸೃಷ್ಟಿ ಮಾಡಿದ್ದೇನೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ ಅಷ್ಟೇ.
Only on the age factor, I will produce the judgment, my lord, to that extent, my lord. Can you pass?
ತಗೊಂಡು
No, only will.
ತಗೊಳ್ಳಿ. ತಗೊಂಡು ಬನ್ನಿ.
Please,
start dictating. Yes. The accused, in a special case number 4246 of 2019, on the file of the learned additional district and sessions judge FTSC1 of Tumakuru, is impugning the judgment of conviction and order of sentence dated 6th November 2021, convicting him for the offence under section 366, 376 of IPC and under section 6 of POCSO Act, and sentencing him to so and so. Facts of the case in brief. ತರಬೇಕು.
I will send, my lords.
Yes, ತಗೊಂಡು ಬನ್ನಿ.
Good.
Facts of the case in brief is that the accused was a minor aged 15 years. The accused is a victim. Victim is a minor aged about 15 years. He was induced by the accused on 12/4/2019 when he came near her house on the motorcycle bearing registration number KA13EL3089. Knowing fully well that the victim is a minor, the accused committed kidnapped the minor girl and thereby committed the offence punishable under section 366 of IPC. It is also the contention of the prosecution that the accused has committed penetrative sexual intercourse with the victim repeatedly and more than once, and thereby committed the offence punishable under section 376 of IPC and under section 6 of POCSO Act. The father of the victim has lodged the first information as per Exhibit P3. After registration of the FIR, the investigation was undertaken and the charge sheet came to be filed. The special judge took cognizance of the offence and summoned the accused. The accused pleaded not guilty and claimed to be tried. Prosecution examined PWs 1 to 14, got marked Exhibit P1 to 17, and identified a MOS 1 to 7 in support of its contention. The accused denied all the incriminating materials available on record, but has not laid any evidence in support of his defense. However, got marked Exhibit D1 during cross-examination of PW1. The trial court, after taking into consideration all these materials on record, came to the conclusion that the prosecution is successful in proving the guilt of the accused for the offence punishable under Section 366, 376 of IPC and under Section 6. Accordingly, proceeded to convict and sentence him as stated above. Being aggrieved by the same, the appellant, the accused is before this court. ಇದು ಕೊಡಿ 2021 to KCCR 1152 AR 2011 AC 715 11 AC 7. Yes, what do you say regarding proof of age? Hmm. He was the headmaster of the higher primary school, not of primary school. Hmm. That is not produced. Ah. Then see the decisions of the apex court is that unless the document ah, age cannot be proved. No, when the apex court has very specifically stated how the age of the victim is to be determined, it is only on the basis of the birth certificate and the school certificate issued by the primary school, not by any other school. Yes. Why? And the victim states she is having birth certificate. Even that was not produced. Whatever may be, but the result is same. That is wrong, Anta. ಯಾರು ಸಿಗ್ಲಿಲ್ವಾ ಯಾರು ಸಿಗ್ಲಿಲ್ವಾ ಓಕೆ If section 6 is taken away, what remains? POCSO 376. 376 ಯಾವ್ದು ಬರುತ್ತೆ? Para number?
Para number 22, 32 minutes. 22 minutes, first minute. Before proceeding further in analyzing the evidence led in the matter, it is borne in the mind that is an appeal against the judgment of acquittal of the offences punishable under section 366, 343, 506B, IPC 6 and 8 of the POCSO. Therefore, the accused have prima facie doubt benefit. Firstly, the presumption under law is that unless the guilt is proved, the accused has to be treated as innocent in the alleged crime. Secondly, the accused has already been enjoying the benefit of the judgment of acquittal under the so as being the same mind the evidence placed by the prosecution in the matter. And the concerned minute 32 minutes, next minute. 32 minutes. Paragraph. The other documents which the prosecution could have been produced and relied upon the SSLC marks card of the victim. Though at the time of the alleged incident, the girl was shown to be studying in her 9th standard schooling. However, the alleged victim girl during evidence of PW8 has stated that she has already appeared in SSLC exam and could not complete the same successfully. As such, the prosecution could have secured the said document in the form of SSLC marks card and produced it court before, which for the reasons best known to it has not done. Had the document been produced, then it would have been answered the very first requirement mandated under rule of J.J. Junior Justice Rules Millards. In the absence of SSLC marks card, the date of birth issued by the school where the victim has firstly attended The next category of the document which the prosecution could have been relied upon and produced is the birth certificate issued by the local authorities, including Gram Panchayat. In that regard, the prosecution could not able to show that the birth of victim was registered with the jurisdictional local authorities. For the matter PW8, Sudha, the mother of the victim, could have been the competent person to speak as the whether the birth of her daughter, that is the victim girl, was registered with the local authority. However, the prosecution did not put any effort to ascertain the details for the witnesses viewpoint. And the judgments have been appreciated at the para number 16, my lords.
1 minute. ಕೊಡಿ. See, this is under the old JJ Act.
Please, notes.
Now JJ Act is 2015 Act has come into force.
Please, notes.
What is the relevant rules? Here there is reference to Rule 12.
Rule 12 minutes.
Procedure to be followed in determination
But
of the
here
age.
also offense of 2000, date of birth is 2002 minutes in with this in judgment.
Maybe when the offense,
2019 minutes.
then 2015 Act is already in place.
Please, minutes.
What is the
Here, my lords, in this case,
procedure?
the 2015, my lords, here offense. These are subsequent, my lords, October 2015, my lords.
Now the procedure as when the inquiry was being held before the POCSO court. The Act of 2015 was in force.
Please, my lords.
Yes. That was not done. Accused ಬಗ್ಗೆ ಇಲ್ಲ ಈಗ. Whether the
Victim,
victim was minor or not.
Even ossification test was not done, my lords. The 2015 Junior Justice, my lord, 94 rule, my lord, presumption and determination of age.
ಎಲ್ಲಿದ್ದಾರೆ ಕೊಡಿ ಅವ್ರಿಗೆ ಡಿಟರ್ಮಿನೇಷನ್ ಆಫ್ ಏಜ್ ಯಾವುದು
94 minutes. 2015 Act 94, determination of age. Where it is obvious to the committee or the board, based on the appearance of the person brought before it under any of the provisions of this act, other than for the purpose of giving evidence that the said person is a child, the committee or the board shall record such observation stating the age of the child as nearly as may be, and proceed with the inquiry under section 14 or section 36 as the case may be, without waiting for the further confirmation of the age. In case the committee or the board has reasonable grounds for doubt regarding whether the person brought before it is a child or not, the committee or the board, as the case may be, shall undertake the process of age determination by seeking evidence by obtaining the date of birth certificate from the school or the matriculation or equivalent from the concerned examination board if available, and in the absence thereof the
old rules are
2015 minutes. 15 minutes.
ಇಲ್ಲ ಅದು
2015 minutes.
rules
2015 Act 94.
huh?
The Juvenile Justice Care and Protection of Children Act of 2015.
2015 huh? Yes.
In this judgment, my lords, at para number 70, my lords, there is some guidelines issued to the Home Department to consider for the how to investigate the POCSO matters, my lord. At para number 70, my lords.
70
Please, my lord, 70, my lords. And page number 70, in Roman 2, my lords. For the age factor, my lord, according to the prosecution, the alleged victim girl PW5 was minor in her age and her date of birth was so and so. We have been observing that in many cases, the investigation officer collecting only the school admission register extract from the school authorities as the sole proof of the date of birth of a minor. Being the responsible police officer, they are expected to know the legal procedure to be followed in providing the age of minor, whether the accused or as a victim. Rule 12 of JJ Act Care and Protection, Rule 2017, as well as the 94(2) of
when age is not proved, what will be the consequence? POCSO will not be applicable.
366, my lord. For that, even only the last scene, my lords. For that, she has accompanied without any raising any alarm, my lords. She stayed for 10 days in the said house, my lords.
When she is a major,
Even in the case, my lord, the victim was kidnapped, my lord. Even it has been considered Roman 5 minutes, page number 73 minutes. According to the prosecution, the accused took the victim girl from her place of residence to a different village on a motorcycle. Even in the case and the same facts minutes.
Third submission, there is a materials point. Answer to the point in the affirmative for the following reasons. It is the contention of the prosecution that the victim was aged 15 years at the time of incident and she was kidnapped by the accused with an intention to marry her and committed penetrative sexual assault repeatedly and thereby committed the offense punishable under section 366, 376 of IPC and under section 6 of POCSO Act. Please be seated. To prove these contentions, prosecution examined the victim as PW1. She deposed before the court in support of her contention and stated that her friend was coming with the accused and thus she came in contact with him. He had taken her photos and was threatening that he will upload it in Facebook. He was also criminally intimidating to cause the death of her parents. And thus he took her to a farmhouse and committed penetrative sexual intercourse. On 12/4/2019, she was with him till 22nd April 2019. During cross-examination of this witness, learned counsel for the accused has elicited that she has not given a statement before the police, that she was knowing the accused and they were liking one another and they have taken a photo in a studio. Witness admitted that the road where she was, the road in which she was proceeding to her school is a public road. And there will be movement of the persons and the vehicles. Witness admitted that she has not tried to gain public attention by screaming or shouting, but she accompanied the accused silently. She had got her dresses from the workers who were working in the farmhouse, but she had not informed them that the accused had forcibly taken her and kept in the farmhouse. Witness also states that while she was with the accused in the farmhouse, she had been to the relative's house of the accused, but she had not complained anything against the accused with them. All these evidence given by the victim PW1 discloses that she might have gone with the accused voluntarily or willingly. Next paragraph. It is the contention of the prosecution that the victim was aged 15 years as her date of birth was 26/2003. To prove the date of birth, the prosecution is relying on Exhibit P7 and the evidence of PW8, the headmaster of BTS High School, Kamparahalli. Exhibit P7 is the study certificate. Date of birth, public study certificate. Witness stated during his evidence that the victim girl was admitted to the high school, to the 8th standard. He issued Exhibit P7 on the basis of the transfer certificate that was available in the register. Transfer certificate issued by the primary school that was available in the register. But the said transfer certificate is not produced. The investigating officer has not collected the birth details that was found in the primary school when the victim was admitted to the school. Interestingly, PW1, the victim admits that she is having the birth certificate, but the same is not produced with the court. Next, section 94 of Juvenile Justice bracket Care and Protection of Children bracket complete Act of 2015. It prescribes the procedure for determination of the age and presumption of the same. As per the rules, it is the duty of the CWC, Child Welfare Committee, to determine the age when the person is brought before it under the provisions of JJ Act. It shall undertake the process of determination of the age on the basis of date of birth certificate from the school or the matriculation or equivalent certificate. Birth certificate given by the corporation or municipality, municipal authority or panchayat, and only if those documents are not available. Age shall be determined by an ossification test or any other latest medical age determination test conducted on the order of the committee or the board. The Honorable Apex Court, the division bench of this court in Mohan Kumar alias Kumar versus State of Karnataka, 2021 2 KCCR 1152, considered a similar case where there was allegation against the accused that rape was committed under promise to marry. The division bench held that the extract of school admission register does not amount to proof of the date of birth of the victim. When section 94 of Juvenile Justice Care and Protection Rules 2015 when section 94 of Juvenile Justice Care and Protection Act of 2015 prescribes the manner in which the date of birth of the victim is to be, juvenile is to be determined, and when it is the settled proposition of law, the determination of age of the juvenile, it is the settled position of law that the procedure for determination of the age of the juvenile would equally apply to determination of the age of the victim under the POCSO Act. I am of the opinion that the prosecution has not undertaken such a procedure by producing the birth certificate of the victim, which she says is available with her, or by producing the school records where the victim first studied to prove her age. Exhibit P7 study certificate produced by the headmaster PW8 of the high school will not prove the date of birth, as it is specifically stated by the witness that he had issued exhibit P7 on the basis of the transfer certificate that was given by the victim at the time of admission to the high school. Next, learned counsel for the learned amicus curiae placed reliance on the decision of this court in state of Karnataka versus Hemant Kumar alias Kumar, based at disposal 21st March 2024, where the division bench of this court again considered the question as to whether the age of the victim was determined in accordance with section 94 2I of JJ Act 2015, held that the study certificate issued by the headmaster of a high school is not admissible in evidence to prove the date of birth of the victim. The division bench has also issued several guidelines to follow the procedure as contemplated under section 94 of Juvenile Justice Care and Protection Act 2015, and to collect prescribed documents to prove the age of the victim. But none of those documents are produced before this court. Under such circumstances, it is to be held that the prosecution has failed to prove that the victim was aged only 15 years and she was a minor. When the prosecution fails to prove the age of the victim, it cannot be said that the offense in question was committed under the provisions of POCSO Act. Next one. While considering as to whether the prosecution is successful in proving the guilt of the accused for the offense under section 366 and 376 of IPC, the evidence of the victim girl examined as PW1 is to be taken into consideration. Tenor of the evidence given by the victim referred to above do not substantiate the contention of the prosecution that the victim girl was forcibly kidnapped by the accused with an intention to marry her to constitute the offense under section 366, or he has committed rape punishable under section 376 of IPC. It is also pertinent to note that the age of the victim, the age of the accused, as shown in the trial court records, was 26 years. 26 years. Both accused and the victim were found in the farmhouse. And they were brought to the police station. And thereafter, the accused was remanded to custody. When the prosecution has failed to prove that the victim was a minor and the accused has forcibly taken her to the farmhouse and both of them and made her to stay there for several days when he committed sexual assault. Come on. It cannot be said that the accused is liable for the offense under section 366 or 376 of IPC. The benefit of doubt will have to be extended to the accused to acquit him for the aforesaid offences. In view of this, I am of the opinion that the prosecution is not successfully in proving the guilt of the accused beyond reasonable doubt. Accordingly, accused is entitled for acquittal. I have gone through the impugned resolution. It has not taken into consideration these aspects of the matter, but based its judgment, based its findings on Exhibit P7 to accept the study certificate issued by the high school to prove the age of the victim, which is apparently wrong and against the procedure as contemplated under law. Hence, I am of the opinion that the impugned judgment of conviction and order of sentence passes so is liable to be set aside. Accordingly, I answer the affirmative. Appeal is allowed.
Obliged.
10,000. High Court Legal Services Committee. Yes.
For admission, serial number 35, Parmeshwaran Hegde.
Hearing for appellants.
Sentence was suspended.
ಅದು ಇಶ್ಯೂ ಇಂಟಿಮೇಷನ್ ಒಂದು ಮಾಡಿಬಿಡಿ ಅದರಲ್ಲಿ. ಇಫ್ ಈ ಅಕ್ಯೂಸ್ಡ್ ಈಸ್ ಇನ್ ಕಸ್ಟಡಿ ಅದ್ರ ಪ್ರಕಾರ 6 months 6 years ಇಂದ ಇದೆ ಅಂತ ಇದೆ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಯಾರು you have to issue notice to the respondent.
Counsel Latif B.
ಯಾರು
For locate.
Special counsel Latif takes notice for respondent. Lokaಯುಕ್ತ ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಯಾರದು respondent wait ಇದು trial court records await trial court records. Yes, await trial court records. The meantime serve the copy and yes.
36, Tigadi Veeranna.
10 years sentence, my lord. During the trial, my lord, on bail, my lord, page number 15, my lord, last one, my lord. During the course of the trial, my lord, he is in bail, my lord, page number 15, my lord. There are three only, last already.
Third, young counsel for the appellant and an additional SPP for respondent number 1 on A1 of 2025 seeking suspension of sentence. And 2, he is on bail, he is in custody.
Custody, ma'am.
He is in custody. And to
Both are
release him on
custody.
bail. The law colleague, he was on bail during trial. There is no allegation of misuse of the liberty. So and so A1 is allowed. Order of sentence is suspended. Order to be released on bail subject to conditions. Heard so and so on admission. Grounds made out of the law colleague. Admit. Call for trial court records. Vandita. List for final hearing. Admitted.
Serial number 37, Arjun. 38, Melon Sebastian. Sridevi Bhosle.
For appellant, your lordships. Appellant is accused number 2, your lordships. In this case, there are 5 accused, your lordship. A1 is absconding. There is separate split up charge sheet
The
against him.
appellant.
Your lordship.
Who is the
Appellant is A2, your lordship. A3 is died. He is abetted in this case, your
Now
lordship.
you are representing whom?
A2, your lordship. Restrict your argument only to accused number 2. Please, your lordship. I have been convicted on under section 8C, read with 21 of NDPS, your lordships, for 14 years, your lordships. Means 4.5 years he's been in custody. He's in your custody. lordship. Yes, your lordship. 10/11/2020, since 10/11/2020, date of arrest, your lordships. During trial, you are in custody. Yes, your lordships. Then you are not entitled for this. Third so and so, or ಹೆಸರು ತಗೊಳ್ಳಿ. On a 1 of 2025. Suspension entitled ಇಲ್ಲ. It is noticed that Notice ಆಗಿದೆ. accused is for charged for the offence so and so, and he was in custody during trial. He is convicted for the offence punishable under section so and so. Under this and sentenced to undergo so and so. Considering the nature of the allegations and also the judgment of conviction and order of sentence passed by the trial court, I am of the opinion that the appellant is not entitled for suspension of sentence. Accordingly, IA 1 of 2025 is dismissed. Admit ಅದು full ಹಾಕೊಳ್ಳಿ. Call for trial court records. IA is dismissed. Appeal is admitted. Call for trial court records. List for final hearing. Next. Much obliged.
Purushottam H.
Time for appellant, my lord, that convicted under section 18 of section 10 of POCSO, my lord. The 3.5 year mean convicted.
Released. Was on bail. Yes. Notice ಆಗಿದೆ ಅವರಿಗೆ. Additional SPP takes notice for respondent number so and so. Called so counsel for the appellant and learned additional SPP on the IA 1 of 2025. ಅದೆಲ್ಲ ಹಾಕಿ was on bail during trial. There is no allegation of misuser of the same so and so so and so. IA is allowed. Issue notice to respondent number 2. ಅದಕ್ಕಿಂತ ಮೊದಲು admit ಮಾಡಿ trial court records call ಮಾಡಿ. Yes, IA allowed.
Serial number 40, PS Basuraja.
For the appellant in this case, my lords.
Yes.
Appellant convicted under section 6 of POCSO Act for 25 years. He was released on bail on 9/11/2023, my lord.
He was on bail?
Yes, my lord.
Yes, he was on bail. Yes. What is it?
ಆಗಿದೆ ನೋಟಿಸ್. ಇದಾಗೈತೆ.
Notice is issued. In this case, he was on bail. Same. 1 of 2025 is allowed. Admit to call for trial court records. Issue notice. Yes, IA is allowed.
Thank you for that.
This two, serial number 1, Aditya D.
Yes.
Lord, the appellant has been convicted for 20 years for offences under 376 AB and section 6 of POCSO Act.
376
AB. AB and POCSO section 6. The crime, my lord, was registered in crime number.
1 minute. Sir.
How many witnesses are examined?
No, totally 11 witnesses are examined. Madam.
Who is PW1?
PW1 is the mother.
Mother.
Yes.
She is the complainant.
Yes.
PW2?
PW2 is the victim. Madam.
PW3?
PW3 is the doctor who examined the child at the hospital.
Medical certificate?
Medical.
Huh? Exhibit P5. Then PW4?
PW4 is the social worker. Madam.
What she has done?
She has been part of the statement that was recorded before the police at the hospital.
She accompanied the victim.
She accompanied.
PW5?
PW5 is the doctor who examined the accused man.
Exhibit?
Exhibit P. Is PW6.
PW6? PW5 is the doctor.
PW5 is the teacher man.
5 is the teacher.
Yes. Who confirms the age of the child.
No exhibit? What is the document?
It's just an endorsement that is been given, my lord. It's exhibit P8. No birth certificate is given. A handwritten endorsement of the age as per school record.
Then PW7?
PW7, Major witness.
Mazur, what Mazur?
To the place of incident. Spot Major.
Exhibit?
P2.
Then PW8?
P8 is the exhibit. PW8 is the IO man.
What he has done?
Investigated the matter.
Complete investigation?
Yes.
He filed the final report?
Yes.
PW9?
PW9 is the
PSI? FSL is exhibit?
6 and
PW10?
6 and 9 man. Yes.
He is a police official?
Yes.
WPC na? Then PW11?
She's the sister of the accused. Sister.
Sister or wife? Accused or relative? Allah, wife of accused.
One second. No, sister. ROP Barkat Nana Anna. Barkat is the accused. PW11 is the sister. PW11 is the sister man.
Sister of accused?
Yes.
All the witnesses have supported?
All the witnesses have supported the, except for PW11, my lord.
She turned hostile?
She is not supported the, she's turned hostile.
Others have supported. Who are the material witnesses?
My lord, the material witnesses are PW1, 2, 3, who the doctor, social worker, and the PW6 and PW7, madam.
What is the age of the victim?
Age of the victim was 9 years, my lord, at the time of incident.
Come to the evidence of PW5.
Lord, evidence?
Evidence of PW5.
Evidence of PW5, madam. Exhibit P8, madam. My lord, this is a certificate of the teacher where she says that the child was promoted from class 2 to class 3. To ascertain, page number 88 is the statement, madam. Deposition before the court. Yes. My lord, the basic aspect that was asked for the witness to confirm was the age of the child, my lord. And the witness in the cross-examination says the following. ನಮ್ಮ ಶಾಲೆಯಲ್ಲಿ 1ನೇ ತರಗತಿಯಿಂದ 7ನೇ ತರಗತಿ ಆಂಗ್ಲ ಮಾಧ್ಯಮ ಶಾಲೆ ಇದೆ. ನಮ್ಮ ಶಾಲೆಯಲ್ಲಿ ಪ್ರಥಮ ಭಾಷೆ ಇಂಗ್ಲಿಷ್, ದ್ವಿತೀಯ ಭಾಷೆ ಕನ್ನಡ, ತೃತೀಯ ಭಾಷೆ ಹಿಂದಿ ಇರುತ್ತದೆ. ಸರ್ಕಾರಿ ನಲಿಕಲಿ ಶಾಲೆಯು ನಮ್ಮ ಶಾಲೆಗೆ ಅನ್ವಯ ಆಗುವುದಿಲ್ಲ. ನಿಶಾನೆ P8 ದಾಖಲಾತಿ ನೀಡಿರುವ ವ್ಯಕ್ತಿ ಅಂದರೆ ಪ್ರಾಸ 2 ನೊಂದ ಬಾಲಕಿಗೆ ಶಾಲೆಯ ಕಲಿಯಲು ಕನ್ನಡ ಭಾಷೆ ಇತ್ತು ಎಂದರೆ ಸರಿ. This becomes the most important factor, my lord, because the statement of the victim, even before the investigating officer and the court, she claims that she did not know Kannada and she only knew Urdu.
What is wrong in it?
No, I'm just bringing it to the notice of the court, my lord. Now, I'll come to the material facts, the evidence that is placed before this court. Then I will draw this court's attention to this.
Nothing has been elicited during cross of PW5.
Nothing has been, other factors have not been elicited. Because
Disputing the birth certificate.
no, there's no, my contention is, my lord, the birth certificate is not issued at all. It is only the endorsement.
Disputing the study certificate also.
The birth certificate is not provided. The IO has not collected the birth certificate at
No,
all.
not about the birth certificate.
Yes.
The study certificate is produced by PW5.
Yes.
You have not disputed.
It has not been disputed on record.
Then,
My lord, I'd like to draw the attention of
as
the
per this document, what is her age?
The age of the child, the date of birth is given, my lord. If the document may be perused, the date of admission is 26/4/2010 and the date of birth mentioned is 24 the 26/4/2010, madam, at the time of incident.
Twenty-four.
26/4/2010.
Date of offense?
My lord, the date of offense is 27 4, my lord.
27,
4,
which year?
2019.
27/4/2019.
Yes. Between
Was studying in 3rd standard.
yes.
Years. 8 years old.
Yes.
Now come to evidence of PW1.
Yes, madam. Page number 60, 63. I read, my lord. ನಾನು ಶಾಹಿ ಗಾರ್ಮೆಂಟ್ಸ್ ನಲ್ಲಿ
So read the relevant portion, not the entire evidence.
ಪ್ಯಾರಾಗ್ರಾಫ್ 4 ಮೇಲೆ
Yes.
ದಿನಾಂಕ 11/5/2019 ಈ ಪ್ರಕರಣದ ಘಟನೆ ನಡೆದಿರುತ್ತದೆ. ದಿನಾಂಕ 12/5/2019 ನಾನು ಆರೋಪಿಯ ಮನೆಗೆ ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆಗೆ ಹೋಗಿದ್ದೆನು. ಅವರ ಮನೆಯಲ್ಲಿ ಆರೋಪಿಯ ಹೆಂಡತಿ, ಮಗ ಮತ್ತು
She says the date of incident 11/5/2019.
Apologies, that's in the FI.
You said 27/4.
My lord, apologies. Note. The note of the incident in the FIR is between those two dates.
Between what date?
My lord?
Between which date?
As per the FIR, my lord, the date of incident has been recorded is 27/4/2019 to 11/5/2019. But the complaint government only talks about one day, man. That is 11/5/2019.
Yes.
ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆಗೆ ಹೋಗಿದ್ದೆನು. ಅವರ ಮನೆಯಲ್ಲಿ ಆರೋಪಿಯ ಹೆಂಡತಿ, ಮಗ ಮತ್ತು ಆರೋಪಿಯ ತಂಗಿ ಶಮ್ತಾಜ್ ಚಾಸ 7 ಮತ್ತು ಅವರ ಮಗಳು ಚಾಸ 3 ರವರು ಇದ್ದರು. ಚಾಸ 2 ನೊಂದ ಬಾಲಕಿಯು ಚಾಸ 3 ರವರ ಜೊತೆ ಆರೋಪಿಯ ಮನೆಯ ಬಳಿ ಆಟವಾಡುತ್ತಿದ್ದಾಗ ಆ ದಿನ ಸಂಜೆ 7:30 ಗಂಟೆಗೆ ಆರೋಪಿಯ ತಂಗಿ ಚಾಸ 7 ಶಮ್ತಾಜ್ ರವರು ನನ್ನ ಕರೆದು, ನಿನ್ನ ಮಗಳು ನನ್ನ ಮಗಳ ಬಳಿ ಆರೋಪಿಯು ಕೆಲಸದಿಂದ ಬಂದ ನಂತರ ಆತನು ಹೆಂಡತಿ ಮತ್ತು ಮಗ ಮನೆಯಲ್ಲಿ ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ನಿನ್ನ ಮಗಳ ರೀಸಸ್ ಮಾಡುವ ಜಾಗಕ್ಕೆ ಕೈ ಹಾಕಿರುತ್ತಾರೆ, ಗುಪ್ತಾಂಗಗಳನ್ನು ಮುಟ್ಟುತ್ತಾರೆ ಎಂದು ಎದೆಯನ್ನು ಚೀಪುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾಳೆ ಎಂದು ಹೇಳಿದರು. ನನಗೆ ಏನು ಅರ್ಥವಾಗದೆ ಇದ್ದುದರಿಂದ ನಾನು ವಾಪಸ್ ಮನೆಗೆ ಹೋದೆನು. ಶಾಲೆಗೆ ಬೇಸಿಗೆ ರಜೆ ಇದ್ದಿದ್ದರಿಂದ ನೊಂದ ಬಾಲಕಿಯನ್ನು ನಾನು ಮೇ 4ನೇ ತಾರೀಕಿನಿಂದ 11ನೇ ತಾರೀಕಿನವರೆಗೆ ಆರೋಪಿಯ ಮನೆಯಲ್ಲಿ ಇರಲು ಬಿಟ್ಟಿದ್ದೆನು. ನಾನು ಮನೆಗೆ ಹೋದ ನಂತರ
The victim girl was left in the house of the accused.
Yes, the incident.
They were neighbors.
They are basically relatives, my lord. The victim girl, due to vacation, was left at their place because the parents of the victim, the mother was working at the garments and the father happens to be a fruit seller. Due to vacation, she was allegedly left at the place of the accused. And at the time when the wife and child of the accused were not there, the alleged incident has taken place is the contention of the complainant.
Yes.
The most relevant aspect is mentioned in para 6, my lord. ನೊಂದ ಬಾಲಕಿಯು ಘಟನೆ ನಡೆದ ದಿವಸ ಮನೆಗೆ ಬಂದಾಗ ಆಕೆ ಹೊಟ್ಟೆ ನೋವು, ಮೈಕೈ ನೋವು ಎಂದು ಹೇಳಿದ್ದಳು. ಆದರೆ ನೊಂದ ಬಾಲಕಿ ಆ ದಿವಸ ಘಟನೆಯ ವಿಚಾರವನ್ನು ಹೇಳಿರಲಿಲ್ಲ. ನಂತರ ದಿನಾಂಕ 13/5/2019 ನೊಂದ ಬಾಲಕಿಯನ್ನು ಖಾಸಗಿ ವೈದ್ಯರ ಬಳಿ ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತೇನೆ. ಅವರು ಮೆಗಾನ್ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗುವಂತೆ ಸೂಚಿಸುತ್ತಾರೆ. My lord, this particular medical doctor has not been named in the charge sheet or been examined, my lord, who happens to be one of the relevant witnesses to point out. ನಂತರ ಮೂರನೇ ದಿನ ನಾನು ನೊಂದ ಬಾಲಕಿಯನ್ನು ಮೆಗನ್ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದೆನು. ಅಲ್ಲಿ ಆಕೆಯನ್ನು ಚಿಕಿತ್ಸೆಗಾಗಿ ಮಕ್ಕಳ ಚಿಕಿತ್ಸಾ ಘಟಕದಲ್ಲಿ ದಾಖಲು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಮೆಗಾನ್ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನೊಂದ ಬಾಲಕಿ ಮೇಲೆ ಆರೋಪಿ ಅತ್ಯಾಚಾರ ಮಾಡಿರುತ್ತಾನೆ ಎಂದು ಗೊತ್ತಾಗಿರುತ್ತದೆ. ನಂತರ ಪೊಲೀಸರು ಮೆಗಾನ್ ಆಸ್ಪತ್ರೆಗೆ ಬಂದು ಬೆಳಗ್ಗೆ 10 ಗಂಟೆಗೆ ನನ್ನ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಸಾಕ್ಷಿಯು ಸದರಿ ಹೇಳಿಕೆ ದೂರನ್ನು ನೋಡಿ ಗುರುತಿಸಿ ಅದನ್ನು ನಿಶಾನೆ P1 ಎಂದು ಸಾಕ್ಷಿ ಸಹಿಯನ್ನು 1A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನನ್ನ ಹೇಳಿಕೆ ಸಮಯದಲ್ಲಿ ಮಹಿಳಾ ಪೊಲೀಸ್ ಮತ್ತು ನೊಂದ ಬಾಲಕಿ ಇದ್ದರು.
Yes. Come to the medical record, medical certificate issued by the doctor as Megan Hospital exhibit.
My lord, it's at exhibit P5, my lord.
P5.
Yeah, 114, my lord. Relevant portion is at next page, 115, my lord. Injuries, no external injuries noted. Logical genital examination, my lord. Hymen is ruptured, no tenderness, redness present in the introitus. The provisional opinion, my lord, was a plausible
Yes.
The provisional opinion of the doctor was, my lord, I am of the opinion that the child is exposed to an act like sexual intercourse.
Yes.
And as per exhibit P7, my lord, which is the final opinion based on the forensic lab's opinion, which is at page 119, my lord, it can be seen report of seminal, the observation and the test conducted for seminal stains. The suspected
The final opinion is also found in exhibit P5.
My lord?
Final opinion of the
No, final
doctor.
is in exhibit P7, my lord. Here,
Opinion is found in exhibit P5 itself.
no, my lord, that is not signed
The
because
perusal of-
it says the sign. In fact, in the provisional opinion, she says that the final opinion will await the FSL report, my lord.
Yes, where the final opinion?
It's exhibit P7, man. The FSL report is exhibit P6. If I can draw the attention to P6 for a moment, my lord.
P6.
P6, man.
You can continue there.
Yes, ma'am.
Yes.
Your Lordship, Your Lordship, see. Your Lordship, serial number 33, it may be heard on marriage, Your Lordship. I thought like it will be heard on custody certificate, Your Lordship. Your Lordship, actually, it is disputed on study certificate, Your Lordship. ಹೌದು ಡಿಸ್ಪೋಸ್ ಆಯ್ತು, ನಾನು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿ.
ಇದೀರಾ ಸರ್? ಕಲಬುರ್ಗಿ ಬೆಂಚ್.
Court officer? Court officer?
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಮಾಡ್ರಿ ಸೀರಿಯಲ್ ನಂಬರ್ 1.
ಇದ್ದೀರಾ?
ಹಲೋ.
Audible ಇದೀವಾ?
ಹಾ ಆಡಿಬಲ್ ಇದ್ದೀರಿ ಮೇಡಮ್. ಇದ್ದೀರಿ.
ಸರಿ ಸರ್ ಆಯ್ತು. ಮೇಡಮ್ ಬರ್ಲಿ.
ಮೊದಲು ಅದನ್ನೇ ಕರಿತೀರಿ ಮೇಡಮ್ ಕಲಬುರ್ಗಿ ಬೆಂಚ್?
ಹೌದು. ಸೀರಿಯಲ್
ಓಕೆ.
ನಂಬರ್ 18 18 ಆಮೇಲೆ 29 ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ.
Madam, 821 ಆಯ್ತಾ ಡಿಸ್ಪೋಸಲ್ ಆಯ್ತು 27 ಸೀರಿಯಲ್ ನಂಬರ್ ಅಪೋನೆಂಟ್ ನೀರಸ್ ಜಾಧವ್ ತೋರಿಸ್ಬಿಡಿ ರಶ್ಮಿ ಜಾಧವ್
ರಶ್ಮಿ ಜಾಧವ್ ತೋರಿಸಂಗಿಲ್ಲ. ಇಲ್ಲ ಇಲ್ಲ ನಾನೇ ಹೇಳಿದ್ದು ಅದು ಮೇಡಮೇ ಮಾಡೋದಿದ್ದಾರೆ ಅದಕ್ಕೆ.
ಅವ್ರಿಗೆ ತೋರಿಸಿದ
ಸರಿ ಕಲಬುರ್ಗಿ ತರಿಸಿದ್ದೀರಾ? ಎರಡು ಸಲ ಒಂದ್ ಸತಿ ಸಸ್ಪೆನ್ಷನ್ ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡಿದ್ದೀರಾ, ಇನ್ನೊಂದ್ಸತಿ ರಿಜೆಕ್ಟೆಡ್ ಆನ್ ಮೆರಿಟ್ಸ್. ಇದು 3ನೇ ಸಲ. ಅಲ್ಲಿ ಏನಿಲ್ಲ ಅದಕ್ಕೆ ನಾಳೆ ಅಂದ್ರು ಅವರು. ಅದು ಇವಾಗ ಏನಾದ್ರು ಮಾಡಲಿ. R1 ಇದ್ದಾರೆ. R2 ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ಓ ಅದಕ್ಕೆ ಐ ಹಾಕ್ಬಿಟ್ರ ನೀವು ಪೋಸ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ನಾನು ಅಂತ. Matter pertaining to Kalburgi bench, serial number 1, Ganesh Nayak.
Your ladyship, appearing for the petitioner. 482 petition, ladyship, for the offence 78(3) of AP Act.
Notice sheet to be filed. Any submission? No? Manuscript document, page number ಯಾವುದು?
Your ladyship, on page number 29 to ladyship, 33 lot, 37. We have given the council submission, ladyship.
You have furnished?
No, ladyship. We have written the council submission.
What is the submission?
Ladyship, that we have not given the typed copy of the daily orders.
Why?
Daily orders, ladyship. Typed copy of the daily orders.
Yes, that is the office objection, sir. Why you have not furnished?
Ladyship, it's covered by decision, ladyship.
What is the decision? You need not have to furnish the typed copies.
No, ladyship. They have not complied the 155 of CRPC, ladyship.
ಏನಂತೆ? I don't know. Sir, why you are not furnishing the typed copies? According to you, it is not necessary.
Ladyship, I will furnish, ladyship.
Simple thing, sir. You have to furnish it.
Please, I will comply.
Where is your senior, Mr. Ganesh Nayak?
Ladyship, he is held up in Kottalam, in Kalburgi bench, ladyship.
Please comply with that.
Please.
The council submission is not accepted. Council for the appellant is appellant undertakes to comply with the office objections. In the meantime, issue notice. In the meantime, HGP takes is directed to take notice. Yes. Pass over on Salaka meeting.
Matter pertaining to Bangalore bench, passed over matters. Serial number 14, Shivudi.
Counsel for the appellant is absent in representation even when the matter is passed over twice and called again at 2:40 p.m. The appeal is of the year 2023. IA 1 and 2 of 2023 were filed seeking condonation of delay and for suspension of sentence. Now again IA 3 and 4 of 2020 ಅದು ಆ ಇಯರೇ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ 3 and 4 of 2023 were also filed seeking similar reliefs. Hence, office has raised objection regarding maintainability of A number 3 and 4 of 2023. I do not find any reason to file IA 3 and 4 of 2023 when IA 1 and 2 of 2023 for similar relief is pending consideration. Hence, office objection is upheld. IA 2, IA 3 and 4 of 2023 are dismissed. There are the appellant is directed to comply with the other office objections. Next.
Serial number 18, B. Latif.
Bail.
Suspension of sentence.
Suspension Allah. Dismissed.
the most not if it is that case to be considered. The medical report says there is no penetrative system.
No, but earlier your similar application was rejected.
Now, not the, as on the date of rejecting the bail petition, the was not undergone the minimum sentence was prescribed in the section 7 of the POCSO Act. Not the medical evidence, everything is it is excluded. Not the fact track section 7 at the most. And
Argue on merits. On merits, I'll dispose of the application.
earlier hearing application was also allowed.
So I will reject this application and post it for final hearing. I will take up the matter. Admit agida. Admit agida. Trial court records bandide. Mattinನೇನು? Yeah, after tomorrow. Next week. Alla, he is in custody alma. Then
6 years right. If none conviction ಕೊಟ್ಟರು 5 ವರ್ಷ.
Heard learned counsel for the appellant and learned ICGP for respondent on IA 1 of 2025. It is noticed that similar application IA number so and so was dismissed as per order dated so and so. I do not find any reason to once again consider the application. Hence, IA 1 of 2025 is dismissed. Counsel for the next appellant submits that the appellant is in custody since how many years?
6 years.
Since about 6 years. And prays for taking up the matter for final hearing immediately. The trial court records are already received. Hence, both the learned counsel are directed to address this argument on merits. The trial court records are received and the appeal is admitted with a order dated 8/9/2022. Hence, list for final hearing. ಯಾವಾಗ? ಗುರುವಾರ. ಫ್ರೈಡೆ ಬೇಡ, ಫ್ರೈಡೆ ಥರ್ಸ್ಡೇ ಪೋಸ್ಟಿಂಗ್ ಇದೆಯಾ? ಹಾಕಿಲ್ಲ ನಾಳೆ ಮಾಡಿ ನೋಡಿ. ಟುಮಾರೋ ಇಲ್ಲೇನಾ ಮಾಡಿ ಮತ್ತೇನು ಅದಕ್ಕೆ ಎಷ್ಟೊತ್ತು ಬೇಕು? ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ 5 ನಿಮಿಷಕ್ಕೆ ಮುಗಿದೋಗುತ್ತೆ.
Serial number 29, Sandesh P. Nadigar, Jayaprakash Reddy.
Received bail. Okay. Discharge order. Your application for discharge was rejected. Complainants appeal. Discharge. They were discharged. What is your grievance?
The offence are made up under section 143, 144, 323, 324, 502, 506 IPC, and also section 31 RS of the SAST PO Act.
How much time you may require?
But on last occasion,
But trial court records ನೋಡ್ಬೇಕಲ್ಲ. I think on the parted matter ತಗೊಂಡಿದ್ದೀವಿ. He will continue the argument. I will take up that. ನೋಡೋಣ ಇಡಿ.
List to serial number 1.
ಅದೇ ಒಂದೇ ಅಲ್ಲ ಇರೋದು.
I draw the attention of this court to exhibit P6, madam. The opinion of the FSL, my lord, with regard to seminal stains. In the opinion, in the bottom part of the opinion, ma'am.
ಆಯ್ತು.
ಅದರಲ್ಲಿ skin tissue not detected, spermatozoa is not detected in item number 4.
When the offense was committed?
Offense was committed on 11/5/2019, madam.
19.
Yes, 2019.
When they examined?
The victim, madam.
Victim was examined?
The victim was examined before the doctor, my lord, on 14/5/2019.
And where is the question of finding seminal stains, skin tissues, spermatozoa? Naturally ruled out.
Agreed, my
I
lord.
can understand if immediately after the offense she was subjected to examination, you are right.
Yes, Lord. The contention, my lord, according to me, in this case, considering the overall facts and circumstances, may attract 7 and not 6, my lord. It's 6 of this one. Because if medical reports now there's no other factors that.
You know, Hyman was not present. It was told. 7 ಗೆ ಬರುತ್ತೆ.
Agreed, my lord, but the factors can also be different to the extent. Because if the medical record may be seen, my lord, there is no conclusive statement by the doctor. In the final report also, I would agree with the observation of this court if the exhibit P5 is looked into, my lord.
Yes.
Where the doctor says that child is exposed to the act like sexual intercourse, there is a possibility, my lord.
That author of exhibit P5 is examined.
She's examined.
Yes, PW3.
PW3.
What she states. What is your cross-examination?
Her cross-examination, my lord, is at page number 82 of the paper book, my lord. The victim has not stated the medical history to me. It is true to suggest that generally, if the child does not eat food in time, the child would sustain stomachache due to acidity. The age of redness in the uterus would be within 48 to 78 hours of my examination. It is false, even though there was no sexual assault or sexual harassment to the victim. I have given exhibit P5 at the instance of the parents of the victim. It is false to say that I have not examined the victim scientifically. The parents of the victim gave medical history to me in Kannada and Hindi. Whether you have tried to obtain the medical history of the victim was in an irritable condition. As such, I could not obtain the medical history of the victim. Since the victim was irritable condition as stated by you at that time, whether you have attempted to take help of the psychiatrist immediately. I have issued requisition immediately to the psychiatrist and pediatrician. The psychiatrist and pediatrician, examined the victim on the next date. It is false to suggest that even though there was no sexual assault or sexual harassment to the victim, I am deposing falsely at the instance of the parents.
That's true. There is no cross-examination with reference to exhibit P5, exhibit P6.
Yes.
Why? What was the basis for her to give her opinion that it is suggestive of forcible penetrative?
My lord, in my humble opinion, my lord, when there was a medical record in exhibit P6, when both compared together, there, considering the medical expert, she should have been able to give more conclusive certification in the final
examination to PW3. There is no reference to exhibit P5.
Yes,
there is no reference to exhibit P6.
My humble effort before this court
I
to
can
defend
understand, sir, you cannot improve that.
I cannot improve that, my lord. I can only draw an inference on the documents on record.
When PW3 has categorically deposed before the court about those documents,
yes,
was it not necessary to cross-examine?
I completely agree with that.
Then in the absence of such cross-examination, we have to rely on exhibit P5. And exhibit P6, I have already given you the reasonable explanation.
Yes, madam. I completely
cannot deny that.
In coming out of my shoes in defense, my lord, I completely agree with this court.
Yes.
But the factors rely, my lord, considering the medical expert, in my humble opinion, should have opined to the reasons more conclusively is my submission, my lord.
What conclusive evidence could be given, sir?
Allah, I mean, what would, if the reasons with regard to, there can be multiple reasons, my lord, for hymen to be ruptured, just not sexual.
Where is the cross-examination?
Cross-examination not available, my lord. And my,
See, in the absence of cross-examination, when an expert gives an evidence,
yes,
and there is no cross-examination, it is not proper on the part of the court to form a different opinion. What is the basis?
I agree, my lord. I agree. That
If there
is
is cross-examination, definitely correct.
yes. I bow down.
Agree with the witness and agree with the defense. Here, there is no such chance.
But observe inference on the medical record, my lord, because
PW two victim also specifically stated about the act.
yes, in fact, reading
These two are sufficient to constitute the offense. Why
yes,
the child
no.
is to be disbelieved? Why the doctor is to be disbelieved? Why the exhibit P5 is to be disbelieved?
My lord, in that regard, my lord, PW11, who's a sister, my lord, she has said there was some financial transaction between the parties. So that is one submission that I could make before this court. And with regard to the aspect of sentencing, my lord, considering the crime was committed before the amendment, it can
10 years.
20 years imprisonment ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಇದು ಅಮೆಂಡ್ಮೆಂಟ್ ಯಾವಾಗ 2018 ಅಲ್ವಾ
2019 madam.
19 with effect from
With effect from 16/8/2019 madam.
Sixteen 2019.
Yes. The incident has occurred on 11/5. The crime was recorded. That's one of my submissions.
Hmm. 20 years, that may be reduced to 10
10.
years.
If the other factors is not, the court is not convinced, my lord, that's the only factor that I have.
Nothing to convince.
Okay.
Unfortunately, there is no cross-examination.
Yes, ma'am. In fact, as a off the record, my lord, this has been very difficult for me to argue this case. When I read this personally, my lord.
See, nothing fatal is extra elicited from
Yes,
PW2.
yes, my lord. That very.
PW6, they are the two PW6.
Yes. PW6 also, my lord, is with regard to PW3, my lord.
They are the main witnesses.
They're the main witnesses, man. In fact, in my humble opinion, even the doctor who preliminarily suggested them to go to Megan Hospital should have been examined by the police, but nothing of that sort has been done.
There must be such cross-examination.
Yes, I completely agree.
In the absence of any cross-examination, we cannot go on finding fault with the prosecution.
But considering that I'm on this side of
Correct.
this thing, I have
You
to
are right
make an attempt.
way.
Yes, I have to find ways to defend this thing, man.
No, I'm not finding fault with you.
Yes, no, I mean as a counsel, my lord, with the case.
I am drawing your attention to the cross-examination
Yes.
of witnesses.
That's the reason I am avoiding to read the cross-examinations to that effect.
How long he is in custody?
6 years, man.
Another 4 years he has to be. Minimum sentence.
Yes, ma'am.
PW2 has specifically stated.
Yes, yes, she has also specifically stated. Can I add one more point, my lord, with regard to Mahajar witness?
Hmm.
Mahajar witness is at exhibit PW7, my lord, is a Mahajar witness. He says that he's ಚಾಸ ಆರು ಜಮೀರ್ ರವರು ಕರೆದುಕೊಂಡು ಬಂದಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿ, ಪಂಚನಾಮೆಯನ್ನು ನಾನು ಓದಿ ನೋಡಿಲ್ಲ ಎಂದರೆ ಸಾಕ್ಷಿ ನನಗೆ ಓದಲು ಬರೆಯಲು ಬರೆಯುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿರುತ್ತೆ.
Spot master.
Spot master. I mean, if I have to draw the attention of this court.
Good.
I can reduce the judgment for reduction of sentence, my lord. This honorable court has reduced the sentence for 10 years based on the same fact of law, man. With regard to
Yes.
I'll produce
Before
that.
amendment.
Before amendment. That has been done by this honorable court of fact.
Yes, I'm not disputing that. Not necessary. Good. Yes, ಅಷ್ಟೇ. The accused in special case 167 of 2019 on the file of the learned additional district and sessions judge FTSC 1 POCSO POCSO Shumoga is impugning the judgment of conviction and order of sentence dated 9th September 2021, convicting him for the offence punishable under section 376 A-B of IPC and under section 6 of POCSO Act, and sentencing him to undergo rigorous imprisonment for a period of 20 years with fine of rupees 50,000 for the offence punishable under section 6 of POCSO Act, and in default to pay fine to undergo simple imprisonment for a period of 6 months. And in view of sentencing the accused for the offence punishable under section 6 of POCSO Act, not passed any order, not passed any separate sentence for the offence punishable under section 376 A and B of IPC. Brief facts of the case of the prosecution is that PW2 is the victim, who was born on 26/4/2010. She was about 8 years during 2019. On 7/5/2019, the accused, who was known to the victim and her family members, took advantage of the situation that during summer vacation, since the school of the victim girl was closed and she was left in his house by the parents of the victim girl, committed penetrative sexual assault in his house and thereby committed the offence punishable under section 376 AB and of IPC and under section 6 of POCSO. It is the contention of the prosecution that the accused had touched the private parts of the victim girl and also committed penetrative sexual assault, aggravated penetrative sexual assault on the victim girl. Since the victim girl, aged is 8 years, developed irritation and pain in her private parts, she informed this fact to her mother, PW1. After a day, and thereafter she was taken to a private doctor who suggested to take the victim girl to Megan Hospital, Shumaga. Accordingly, the victim was taken by the mother to Megan Hospital, where PW3 examined the victim girl and issued Exhibit P5. After coming to know that the accused has committed aggravated penetrative sexual assault on the minor girl, PW1, the mother of the victim girl, lodged first information as per Exhibit P1. The FIR was came to be registered and the investigation was undertaken. After completing the investigation, charge sheet came to be filed. The special judge took cognizance of the offence and summoned the accused. The accused, has appeared before the trial court, pleaded not guilty for the charges leveled against him. Prosecution examined PW's 1 to 11 and got marked Exhibit P1 to 22, marked MO1 in support of his contention. The accused has not laid any evidence in support of his defense, however, denied all the incriminating materials available on record in his statement recorded under Section 313 of CLPC. Trial court, after taking into consideration all these materials on record, came to the conclusion that the prosecution is successful in proving the guilt of the accused for the offence punishable under Section 376 AB of IPC and under Section 6 of POCSO. Accordingly, it is convicted the accused for the said offence. However, sentenced him for the offence punishable under Section 6 of POCSO as stated above. Being aggrieved by the same, the accused is before this court. Heard so and so. Here is the material. Point for consideration. My answer to the above is partly affirmative for the following reasons. It is the contention of the prosecution that the victim was aged 8 years during May 2019 when the incident had occurred. In support of such contention, the prosecution has produced Exhibit P8, the study certificate issued by the headmaster of the Model Higher Primary School, examined as PW5. This witness has deposed about the victim studying in the school since from first standard and issuance of study certificate as per Exhibit P8. As per Exhibit P8, the date of birth of the victim was 26/4/2010. Therefore, she was about 8 years at the time of incident. Even though this witness was cross-examined by the learned counsel for the accused, there is absolutely no dispute with regard to genuineness of Exhibit P. There is no cross-examination to PW3 on the said document. Therefore, I do not find any reason to reject the evidence of PW5 or to reject Exhibit P8. Hence, Exhibit P8 could be relied on to determine the age of the victim as 8 years as on the date of incident. Next, it is the further contention of the prosecution that PW1, the mother of the victim, and her husband, the father of the victim, were working for their livelihood During May 2019, since there was summer vacation to the school, the victim was left in the house of the accused, who was distantly related to PW1. Taking advantage of this situation, the accused, who was aged 44 years, committed sexual assault and later sexual assault by touching the private parts of the victim girl and inserting his fingers in the vagina, and later committing aggravated penetrative sexual assault, committed rape. Initially, the victim has not complained of this act with her mother. When she started experiencing irritation and pain in the private parts, she informed this fact to her mother, who took her to a private doctor, who in turn advised the victim to be taken to Megan Hospital. Accordingly, the mother had taken the victim girl to the Megan Hospital. It was PW3 who examined the victim girl and issued Exhibit P5. Exhibit P5. As per Exhibit P5, victim was examined with a history of sexual assault committed by the maternal uncle of the victim girl since 15 days, as he has sexually exploited the victim girl. On examination of the victim girl, the medical doctor, the PW3 noticed that the hymen was ruptured. She has given her opinion that the child is exposed to an act like that of sexual intercourse. Accordingly, she has deposed before the trial court as PW3. This witness was casually cross-examined, and it is only suggested that a false certificate is issued by her. And the same was denied by the witness. Nothing has been elicited from PW3 to disbelieve her version or to disbelieve Exhibit P5. When a categorical opinion is expressed by PW3 in Exhibit P5 to state that the hymen of the victim was ruptured and she was subjected to an act she was exposed to an act like that of sexual intercourse in the absence of any serious cross-examination to elicit any contradictions. I do not find any reason to reject these material evidence before the court. Next. The victim is examined before the trial court as PW2. A child of tender age was questioned by the court regarding her capacity to understand the question and to give rational answer. She stated that she was studying in 3rd standard and specifically stated about the act committed by the accused regarding the sexual assault by touching her private parts, and she experiencing the pain and irritation, and also stated that the accused has committed penetrative sexual intercourse, as a result of which she started she experienced burning her bed. The child stated that there was burning sensation in her private parts. She also stated that her mouth was gagged by the accused and criminally intimidated to cause the death of her parents, and therefore she has not informed this fact to her parents. Even though the witness was cross-examined at length, nothing has been elicited during cross-examination. She reiterated her contention regarding commission of the offense by the accused. PW1 is the mother of the victim who logged the first information as per Exhibit P. This witness stated that since she and her husband were working for their livelihood, they have left the victim girl in the house of the accused during summer vacation. And the incident had occurred on 11/5/2019. The victim girl informed her about the incident, about the offense committed by the accused, and also the penetrative sexual intercourse committed by him. She fully corroborates the evidence of PW2 and supports the contention of PW3 and Exhibit P5. PW4 is the social worker who accompanied the victim to the police station when her statement was recorded. PW6 is the doctor who examined the accused and issued the medical certificate as per Exhibit P9. PW7 is the witness to the spot Mahazar Exhibit P2. PW7 to 10 are the 8 to 10 are the formal witnesses. PW11 is the sister of the accused who has not supported the case of the prosecution. Next, from the materials on record, the prosecution is successful in proving the guilt of the accused for the offense punishable under Section 376. AB, capital AB, and under Section 6 of POCSO Act, 376 AB of IPC, and Section 36 of POCSO Act. And accordingly, the accused is liable for conviction. Next. Section 42 of POCSO Act deals with alternative punishment. When the act complained of, when the act of the accused proved before the trial court constitute an offense under Section 376 AB and also under the provision under Section 6 of POCSO Act, the offender found guilty of such offense is liable for punishment under POCSO Act or under IPC as provided for punishment which is greater in degree. But here you see 376 AB. So section 42, greater in degree the punishment should be. So trial court was right. So then the conviction may not be under section 6, under 376 A and AB. So because the amendment was in the year 2018 with effect from 21/4/2018. So offense is 19. So I only modify that. ಅಷ್ಟೇ ಮೇನ್ ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಅಷ್ಟೇ ಅಷ್ಟೇ ತಗೊಳ್ಳಿ ಅಲ್ಲಿ ಮೇಲೆ ನೆಗೆಟಿವ್ ಅಂತ ಮಾಡಬೇಕು. ಗ್ರೇಟರ್ ಇನ್ ಡಿಗ್ರಿ ಏನು ಬಂತು? Greater in degree. Section 376 AB, as it stood as on the date of incident, that is on 11/5/2019, was punishable with not less than 20 years, rigorous imprisonment for a term not less than 20 years, which may extend to imprisonment for life, or for imprisonment for the remainder of that person's natural life, or and with fine, or even with the death. Even with death. As per section 6 of POCSO Act, as it stood on 11/5/2019, it was punishable with the rigorous imprisonment, which shall not be less than 10 years, but may extend to imprisonment for life, and shall also be liable to for fine. Section 6 was amended with effect from 16/8/2019 to enable imposition of the minimum sentence of rigorous imprisonment for a term which shall not be less than 20 years from 16/8/2019. Therefore, as on the date of incident, the punishment, the minimum sentence prescribed under section 376 AB was 20 years rigorous imprisonment, which may extend to death, whereas the minimum sentence for the offense under section 6 was 10 years rigorous imprisonment for 10 years, which may extend to death, which may extend to imprisonment for life. By applying section 42, the accused is liable for sentence under section 376 AB and not under section 6 of POCSO Act. I have gone through the impugned judgment of conviction, and the trial court has properly appreciated the materials on record. But instead of sentencing the accused under section 376 AB, it has sentenced under section 6 of POCSO Act. However, minimum sentence, accused was sentenced to undergo rigorous imprisonment for a period of 20 years. In such circumstances, the impugned judgment of conviction and order of sentence, impugned judgment of conviction is liable to be confirmed. Sentencing of the accused under section 6 of POCSO Act is to be modified as the sentence under section 376 AB of IPC. Yes, I partly in the affirmative nearly. Proceed to pass the following. Affirmative for the following reasons. Partly in the affirmative. Appeal is allowed in part. The impugned judgment of conviction being passed by the so and so in so and so is confirmed. The order of sentence passed by the trial court for the offence punishable under Section of POCSO Act is modified and he is sentenced to undergo rigorous imprisonment 20 years and to pay a fine of rupees 50,000 and in default to pay fine to undergo imprisonment so and so alleged remedy for the offence punishable under Section 376AB of IPC. Send the other portion of the order of sentence shall remain as it is. Other portion of the sentence passed by the trial court shall remain as it is. Yes. Instead of 6 of POCSO, 376 AN.
Serial number 29, Sandesh P. Nadigar, Jay Prakash Reddy.
ಈಗ ಆಗಿದ್ದು ಯಾವುದು?
Complainant, my lords, after recording evidence before charge, the accused were discharged, my lords.
Yes.
That's the offences are, my lords, section 143, 144, 323, 324, 504, 506, read with 149 and 31R and 31S of SC/ST PO Act, my lords. My lords, the only ground for the discharge, my lords, assigned by the Sessions Court is that the medical record is not produced, my lords, by the complainant.
Yes.
But the Sessions Court has observed in the judgment that there was a quarrel that took place between the complainant and the accused. The complainant belonged to a SC/ST community was also observed, my lords. It was also observed that frequent quarrels with regard to the same issue was going on between the accused and the complainant.
And there is no date, time and place of offence in Exhibit P8.
Please, my lords. Exhibit P8, my lords.
Complaint. Exhibit P8. What is this?
Private complaint, my lords.
Private.
Please.
So when there is no date, time and place of offence mentioned in the private complaint, when there are no medical evidence.
That's when in the absence of medical evidence, my lords, only 324 would not attract, my lords. The independent eyewitness, my lords, PW3.
In the absence of any such document, how can you improve your case?
Lords, only 324 would.
Can it be stated that there are prima facie materials?
Lords, the eyewitness to the incident, PW3, has supported the case of the complainant, my lords.
What he says?
My lords, she has told in her own statement as well as in the evidence that the incident took place. Her house is 100 meters away from the place of the incident.
When?
My lords, evidence of PW3, my lords.
PW3. How many witnesses are examined?
2 witnesses, my lords. Complainant, her husband, and the eyewitness.
2 witnesses.
3, my lords. Complainant, her husband, and the eyewitness.
And 2 documents are marked.
8 documents.
8 documents.
Please.
Exhibit P8. PW1 is?
The complainant herself, my lords.
PW2?
Husband of the complainant.
PW3?
Eyewitness, my lords, who resides near the place of alleged incident.
PW2 is not an eyewitness.
No, my lords. He came to the place of incident after the incident took place, my lords. He was the one who took the complainant to the hospital and admitted her.
ಇದೇನು ಕಂಪ್ಲೇಂಟ್ ನೋಟಿಸ್ ಆಗಿದೆ
Accused.
ಅದೇ ಅಕ್ಯೂಸ್ಡ್ ಯಾರು ಇಲ್ಲ he was there ಈಗ ಅವರು ಇಲ್ಲಲ್ಲ ಇವ್ರಿಗೆ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ In all, how many accused?
My lords, 11 accused.
The nature of allegation in exhibit P1 is entirely different from what the PW1 deposes before the court.
In exhibit P1, it is said that avachya shabdagalinda
There is only reference to accused number 1 assaulting.
assault, and it is also alleged that avachya shabdagalinda ನಿಂದಿಸಿರುತ್ತಾರೆ ಅಂತ
Accused number 1 only.
Pardon, Manoj.
Only accused number 1.
But the eyewitness has deposed that she has seen all of them.
I am asking you, there is inconsistency in exhibit P1, the private complaint, and the version of PW1.
Please.
There is some allegation against accused number 1.
Please. ಇದರಲ್ಲೂ ಬೋವಿ ಜಾತಿಯನ್ನು ನಿಂದನೆ ಮಾಡಿ ಸಾರ್ವಜನಿಕ ರಸ್ತೆಯಲ್ಲಿ
So accused number 1 matra. What about not accused number 2 to 11?
Please.
Why private complaint against 2 to 11?
That's the complainant had earlier approached the police milots, and the exhibit P3 milots is the endorsement given by the police stating that the dispute is civil in nature. Only then the private complaint was given.
I'm not on that point.
Please.
At the earliest point of time, you filed the private complaint as per exhibit P1.
Yes.
There is no date, no time, no place where the incident had occurred. Moreover, you state accused number 1 along with accused number 2 to 11 have came. Accused number 1 started scolding in vulgar language, beaten her with hands and sticks. There is no overt act, no scolding, no use of vulgar language, no assault by accused number 2 to 11. Then why they were arraigned as accused number 2 to 11? And when we come to the evidence of PW1,
yes,
you suddenly state accused number 1 has abused, and along with accused number 2, 7 and 9 have also came there and criminally intimidated.
Please.
That is an improvement. And there is no medical records. PW3, the eyewitness says you sustained bleeding injuries. Your clothes were stained with blood.
In this one statement, Malaj, the complainant has stated that the police have taken the medical records while she had approached the police, Malaj. Para 3 of this one statement of PW1.
If that is so, it should find a place in the private complaint.
Please. It's not
Right?
stated in the private
Not
complaint.
stated. And how can your version could be believed?
Even in that event, my lords, 324 would go, my lords. 323 is the assault by using bare hands and legs.
It is only against accused number 1,
Please.
not against any other accused. Private complaint refers to the overt act by accused number 1 only. What is the vulgar word on the ಏನ್ ಮಾಡಿದ್ದಾರೆ?
In the exhibit P1 it is stated that ಬೋವಿ ಜನಾಂಗವನ್ನು ಸಾರ್ವಜನಿಕ ರಸ್ತೆಯಲ್ಲಿ ನಿಂದಿಸಿದರು ಅಂತ. PW3
PW1 she never states anything.
PW1 in her chief evidence has stated at para number 1. ಇಟ್ಟಿಗೆ ಹಾಕಿಕೊಂಡು ಬರುತ್ತಿದ್ದೆವು. ಆರೋಪಿತ ಸುಶೀಲಮ್ಮ, ವೆಂಕಟೇಶ್, ರಾಜು, ಕೌಶಲರವರು ಅವಾಚ್ಯ ಶಬ್ದದಿಂದ ಸ್ಟೇಟೆಡ್.
ಏನು ಹಾಗಂದ್ರೆ what is the meaning of that?
I'm not aware of the meaning.
You are not aware, I am not aware.
Let's to seek instruction, the parties are also not ready to contact.
Correct.
That is the reason last date I made a submission that they have sought NOC from me. That also, when I had called to seek instruction, they scolded me only back. The process to the 11 accused, I have paid it out of my pocket. For that also, they have not approached me.
Leave it. I will dismiss this.
So only with respect to accused number 1 and 2, maybe remanded.
No, very inconsistent. Glaring inconsistency in exhibit P1, in evidence of PW1, evidence of PW3. If we take into consideration these three, we have three different versions, and there is nothing to invoke the provisions of special enactment.
That is the reason the Sessions Court discharged the reasons assigned
in it. And moreover, no medical evidence.
With respect to medical evidence, 324 only would go is my submission.
So when it is your contention, you have sustained bleeding injuries, head injury, there was bleeding from nose.
Please.
And even your clothes were stained with blood. There must be something. And according to you, PW2 has taken you to the hospital. Where is the record? All this falsifies the contention.
So one statement it is stated, Malad, so that the medical records were handed over to the police. I had also asked to get some piece of medical records.
If that is so, see, there must be something in exhibit P1.
Please.
Medical record ittu kotvi, blood stained clothes ittu kotvi, ella tagondru madlilla, then I can believe you. Nothing. Enu illa tagolli. The complainant in the special CC 20 of 2021 on the file of the learned first additional district and sessions judge Chikbalapur is impugning the order dated 19th November 2022. Discharging case number 1 to 11 for the offence punishable under section 143, 147, 148, 323, 324, 504, 506, read with section 149 of IPC and under section 31R and S of SC Prevention of Atrocities Act. So the case in brief is that the complainant has filed a private complaint in PCR 1 of 2021 against case numbers 1 to 11 alleging commission of the offence punishable under sections 143, 144, 323, 324, 504, 506, read with section 149 of IPC and under section 31R of the CH Prevention of Atrocities Act. Alleging that accused number 1 came with other accused and assaulted the complainant with hands and stick, abused her in Hindi language, caused injuries. The complainant approached the Chelluru police station for the purpose of lodging the first information, but the same was not accepted. And no criminal case was registered. Therefore, the private complaint was came to be lodged. The trial court summoned the accused and recorded the evidence of the complainant and two witnesses as PWs 1 to 3 before charge. PW1, being the complainant, deposed before the trial court that on 29/9/2020 at about 7:30 to 8:30, when she was transporting sand and bricks in a tractor for construction of her house, accused Sushilama is accused number?
Accused number 2.
2. Venkatesh?
Accused number 1.
1. Raju?
Accused number 10.
Kausalya?
Accused number 4.
Accused number 1, 2, 4 and 10 have came and abused her in Hindi language and prevented her from proceeding further. Accused number 2 had gone and brought other accused. Accused number 1 assaulted the complainant with a club on her head, waist and limbs. Accused number 2, 7 and 9 have criminally intimidated her, held her hair and pushed her on the pile of stones. In the meantime, her husband came to the spot and taken the injured to the hospital as she sustained bleeding injuries. Taken to Chelluru Hospital as she sustained bleeding injuries. Since the police have not registered any complaint, she filed the private complaint. During cross-examination, witness stated that in the matter of the card notice was also issued. The husband of PW1, he is not the eyewitness to the incident, but states that on the date of incident, he had taken PW1 to Chelluru Hospital for treatment. Police have not taken any action, and therefore the private complaint was filed. During cross-examination, witness states that he is having medical records for having admitted PW1 to the hospital and for her discharge. He came to the spot on receiving the information from his mother-in-law over phone. Witness states that there was a road which was in existence before construction of the compound wall by the accused. He states that he has not produced any document to show that there was a road that was in existence He has also not produced the license for construction of obtained from the panchayat. PW3 is the eyewitness to the incident. He states that during 2020, accused number Venkatesh is accused number 1 now.
Venkatesh is accused number 1, ma'am.
Rajanna,
ರಾಜಣ್ಣ ಅಂತ ಯಾರು ಇಲ್ಲ.
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 accused number 10 Raju idar. Lakshmipati, F5.
Lakshmipati is accused number 5.
Sushilamma,
Accused number 2.
accused number 1, 2, 5 and 10. Sujatamma,
Accused number 7.
accused number 1, 2, 5, 7 and 10. Have assaulted PW1 at about 8 a.m. She sustained head injury. They abused her in filthy language. Witness stated that PW1 had also bleeding in her nose. PW2 came to the spot and pacified the situation. The injured was taken to the hospital. Witness states that the clothes worn by PW1 was stained with blood. He also states that at the time of incident, there were nobody else except himself. It is pertinent to note that as per Exhibit B1, it was only accused number 1 who assaulted PW1 with hand and stick and pushed her on a heap of stone, which resulted in her injury. As per PW1, again it was accused number 1 who assaulted with a club and pushed her on a pile of stones. Accused number 2, 7 and 9 have criminally intimidated to cause her death. There is absolutely no allegation against any of the other accused except accused number 1 in Exhibit P1. In the evidence of PW1, except stating the overt act against accused number 1, 2, 7 and 9, there is nothing against the other accused. As per PW3, it was accused number 1, 2, 5, 7 and 10 who have came and assaulted PW1. According to PW1 and 3, the injured PW1 has sustained bleeding injuries. And the injured was taken to Chelur Hospital. Witnesses state that they have obtained discharge summary and the wound certificate. None of these documents were produced with the court. According to the learned counsel for the appellant, the blood-stained clothes worn by PW1 were handed over, blood-stained clothes worn by PW1 and the medical records were handed over to the police while filing the first information. Even then, the police have not registered the FIR. But strangely, no such contention is raised in the private complaint Exhibit P1. Moreover, there is nothing on record to contend that the accused have abused in filthy language by referring to the caste of PW1 with an intention to humiliate her within public eyes. Under such circumstances, under that, if the materials are recorded or taken into consideration, there are glaring inconsistencies in the evidence of PWs 1 to 3 and in when compared to Exhibit P1. Admittedly, no medical records were produced before the prima facie constitute a cognizable offense. Under such circumstances, the accused are entitled to be discharged. I have gone through the impugned order passed by the trial court. It has taken into consideration all these materials on record and came to the conclusion that there are no prima facie materials to constitute the offense, and therefore accused number 1 to 11 were discharged. I do not find any reason to interfere with the same. Accordingly, I answer their requirement. In the negative and proceed process. Yes, appeal is dismissed.
Lordship, one submission. Lordship, one submission, Lordship. One consideration is serial number.
No, that was considered,
Your
Amma.
Lordship,
That was on merits.
Age is disputed.
No, no,
Your Lordship,
no, no.
age is disputed.
I will not permit.
At cross examination.
Already dismissed. Already dismissed.
POCSO 6 is not applicable. Your Lordship.
ಅದೆಲ್ಲ ಮೊದಲೇ ಹೇಳ್ಬೇಕಿತ್ತು ಈಗ.
Your Lordship, this
Yes.
is my first appeal.
Yes,
One
what is-
opportunity may be given, Your Lordship.
Sir.
ಏನ್ ನಿಮ್ದೇನಿದೆ?
Sir.
ಹಾ ಏನಾಯ್ತು? ಆಯ್ತು, ಇವಾಗ ಅದು ಎಜ್ಜನ್ ಆಗಿದಲ್ಲ ಮಾಡಿ ಹೋಗ್ಲಿ ಬಿಡಿ.
ಇಲ್ಲೇ ಇದ್ದಾರೆ, ಕೋರ್ಟ್ ಒಳಗಡೆ ಬರೋದಿಲ್ಲ. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಲಾಂಗ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್.
ಅಲ್ಲ ನೀವು ಯಾರಿಗೆ? ನೀವು ಯಾರಿಗೆ?
ಶಾರ್ಟ್ ಡೇಟ್.
ನೀವು ಯಾರಿಗೆ? ನೀವು ಯಾಕೆ ಬರ್ಲಿಲ್ಲ? ನೀವು ಯಾಕೆ ಇರ್ಲಿಲ್ಲ?
ನಮ್ಮ ಇವ್ರು ಬರ್ತಾರೆ ಅಂದ್ರೆ ಕೇಳಿದಕ್ಕೆ ಅವ್ರು ಇದ್ದಿದ್ದಕ್ಕೆ ಪಾಸ್
ಸುಮ್ಮನೆ ಕಣ್ಣು ಮುಚ್ಕೊಂಡು ನಿಂತಿದ್ರಲ್ಲ ಅವ್ರು.
ಸಾರಿ ಮಾತು.
ಅದ್ರಲ್ಲಿ ಅಷ್ಟೇ ಹೇಳಿ ಏನು ಇವರಿಗೆ ಅದರಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ನಾಟ್ ಕ್ಯಾರಿಡ್ ಔಟ್ ಅಂತ ಬರ್ದಿದ್ದೀನಿ ಅನ್ಸುತ್ತಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ನಲ್ಲಿ. ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲ ಮಾಡಿಸಿ ತಗೊಳ್ಳಿ. ಆಮೇಲೆ ಒಂದು ವೀಕಿಗೆ ಇಡಿ. ನೆಕ್ಸ್ಟ್ ಯಾವಾಗ? ಹಾಂ 30th.
Your Lordship, it is my first appeal consideration.
ನೋಡೋಣ, ಮೆರಿಟ್ಸ್ ನೋಡೋಣ.
Your Lordship, this is my first appeal.
ಇಲ್ಲಮ್ಮ,
Consideration, Your Lordship. Age
ಒಂದ್ಸಲ
factor is there, Your Lordship. POSCO 6 is not.
Specifically, I asked whether you are addressing the argument on merits.
Your Lordship.
You specifically said no.
One opportunity, Your Lordship. First appeal, Your Lordship, one opportunity because.
No.